This is Tanya Anthony.
Oh, okay. There you are. Got it.
Yeah, I'm here.
Okay.
I had to find a quiet spot.
No, that's okay. We had to pick you up, but your box had to light up on the screen. All right. What is plaintiff's claim in this case?
Your Honor, I'm showing that there is a balance of $393.29, court costs of $242, for a total of $635.29 currently due.
And ma'am, how are you intending on getting that paid?
I honestly wasn't planning on paying it because if there was an issue that we had back in February and March where I received a water bill that was over $12,000. And I went to Kenya, that was the management in the office, and I brought it to her attention and told her that the water bill was incorrect. She said give her some time. She would look into it. Over a couple months, she eventually looked into it and she was able to fix the issue and had the water bill reversed because it was incorrect. But in that time of those couple months where she wasn't able to check it out, I had court fees and fines from then. And so like since February, March until now, I've been paying my regular amount of rent.
You said,
yeah, I got, I don't know if you have the ledger, but
I do not.
Okay, so I want to say it was like March or May. I had got court fees and fines for $240. And that was from the water bill being on there for so long until she was able to adjust it. So when she was able to fix that, she told me that what she couldn't do was go into there and remove the court fees and fines that was put on there because of that reason. She had to talk to somebody that was above her to get those removed. And for me to continue paying my normal rent and my normal water bill that I was receiving. So I would continue to do that, but the court fees and fines were never removed. So it would continue to roll over every month.
Okay.
And then at the end of the month, they went, yeah.
I got you. All right. Here's what I'm going to do. I'm going to adjourn this out 1 week to the 19th. December 19th, 2025 at 2 p.m. That is an in-person hearing. All right. And then that'll give the attorneys time to look into what you're indicating, and then we'll see where we go from there. Okay.
Is there any way that it cannot be Friday? I have my godfather's funeral that I'm attending that day.
Well, I only do these cases on Friday, ma'am.
Okay.
And then my problem is I'm into the holidays and I can't get you in. All right.
Your Honor, I would just like to state I'm reviewing the ledger. I don't see any court fees from March. However, I do show that there was a fee from October and that needs to be reversed. So I will have that reversed. However, the amount that I did state on the record does not include that because we already took it off. My client just has to adjust the ledger accordingly. So.
Oh, okay. So you took off the October one and this is what's left.
Yeah, that's correct.
Yeah, okay. If you look at the ledger,
I'll touch base with my client.
It's more court fees and fines between March and October. It was I got court fees and fines at least three times.
Ma'am.
Okay.
I can't because I don't have the ledger in front of me. So I know. You guys are talking in a space I can't even look at right this second.
Okay.
All right.
Okay.
So the only day I have is Friday, so I'll set it for the 19th at 2 p.m.
Thank you.
Okay.
Thank you.
Thank you.
Arbor Woods versus Tanisha Booker.
Sydney Fontanella, P86316 for the plaintiff, Your Honor.
Tanisha Booker.
There you are. Okay. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. I'm showing that there's rent due of $3,751.07, court costs of $186, for a total of $3,937.07 currently due.
All right. And Ms. Booker, how are you intending on trying to get this paid?
I have $2,100 that I can pay today as soon as I get off work. I get off at 4:30, so I'm gonna try to make it because I know they close at 5. And then, of course, I don't get paid for another 2 weeks. And like you said, we're going into the holidays, so I can do my best to have it paid before you issue me to come back to court on the 19th, I'm assuming.
All right. So let's do this. You're gonna pay 2,100. I'll just indicate by Monday, the 15th, I think it is.
Yes.
Okay. Pay that by the 15th. And then what I'll do is then we'll be looking at a different balance, certainly. And then I'll adjourn this out to December 19th, 2025. I'm ready to go to 26 at 2 p.m. Okay?
All
Thank
right,
you.
I appreciate it.
That's an in-person hearing. You also feel free to contact the attorney's office, see if you can work out a conditional order dismissal regarding it to get this
Okay.
paid, all right?
Okay, am I allowed to do a request for it to be on Zoom if I can't get that day off work?
You can send in the request, but they're
Okay.
set for in-person hearings, ma'am. So I can't
Okay.
say that it'd be granted. All right?
All righty, appreciate it.
Thank you.
Bye.
Arbor Woods versus Flora Boone.
Sydney Fontanella, PH 6316 for the plaintiff.
Flora Boone. They are not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. This is a non-payment of rent case. There is current rent of $1,358.78, court costs of $186, for a total of $1,544.78. I am requesting a default judgment to enter with writ to issue in 10 days, which would put us at December 22nd.
Guys, writ to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. Arbor Woods versus Shayton Campbell and Diane Taylor.
Present. How you at?
Oh, Campbell, hello.
Hello, can you hear me?
Yeah, barely, but we can hear you. Okay, you're Miss Campbell?
Yes.
Okay. All right, what is plaintiff's claim in this case?
I'm sorry, Your Honor, what case is this?
This is it Shayton Campbell? Or Shaitan Campbell and Diane Taylor? Case number is 25-1C 4417.
All right, I found it. Sorry, Your Honor, it was out of order. Your Honor, this is a non-payment of rent case. I am showing that there is rent due of $1,364.47, court cost of $242, for a total of $1,606.47 currently due.
All right. And ma'am, how are you intending on getting that paid?
I get paid next Friday.
You say again?
I get paid next Friday.
And you can pay the full amount, you think? Ms. Campbell?
Yes.
Okay, and how much are you telling me you can pay next Friday?
All of it.
All of it. Okay, can you get that done before, say, 1 o'clock that day?
I'm sure gonna try.
Okay. What I will do is I'll adjourn it out to December 19th, 2025 at 2 p.m. That's an in-person hearing. If you get it and make sure that everything's paid by then, I don't need to see you.
Okay.
All right,
sounds
but it's
good.
got to be paid well before the court time, okay?
Yes, sir.
All righty. Thank you. Have a good
Thank you.
weekend.
Have a good rest of your day. Yes,
ma'am. Arbor Woods versus Felicia Hugan and Reginald Hugan.
Sydney Fontanella
And Miss,
for the plaintiff.
hello? All right, and Mr. Hugan's here. All
Yes, sir.
right. How much is owing?
Your Honor, I'm showing that there's rent due of $1,786.27, court costs of $242, for a total of $2,028.27.
All right, Mr. Hugan,
Yes, sir.
how are you intending on getting that paid, sir?
I'm trying to get it all paid by the 29th. My wife just had surgery, broke her wrist, so She haven't been working in 3 weeks, so I get paid on my next payment's on the 26th, and hopefully we have it all. She's actually going to, as we speak, trying to get assistance now, but hopefully it'll be paid. I'm quite sure it'll be paid by the 26th. I'm sorry, the 29th.
Okay, when you say she's trying to get assistance, is she trying to get through Hawk?
I'm not. She's going down to the DHS right down in Ypsilanti somewhere.
Oh, okay. And
Yeah.
she's gonna do an SCR. Okay, so if she does that, in your packet, there's a rental assistance form.
Okay.
You guys would need to fill that out.
Okay.
Okay, and submit that to the court, by next Wednesday, once she has a tracking number.
Okay. So like I said, she's actually turning in the papers today, I think. Yes.
Got it. Okay, so she'll get a tracking number, and then we'll be able to do that. You can also contact Hawk and see whether or not they'll be able to help you out.
Hawk, is that okay? We'll look that up.
Yeah, that you got something to write with? That number's
no, I'm sorry, I'm at work. No, I don't right now.
Okay, it's okay. It's 961-1999 is their number.
961-1999. That's
Yes,
734, am I correct?
Yes, sir.
Okay.
All right.
Matter of fact, I'm gonna call after because I was waiting on the amount so she can take that amount down there and see what happens.
Okay. So I'll adjourn this out 1 week to the 19th, 2025 at 2 p.m. As you know, that's an in-person hearing. All right.
I'm off. Yep, I get off at 1 o'clock, so I'll be there.
All right. Very good. All right, Mr. Egan. Take care. Have a good weekend.
Thank you, sir. You have a blessed one. Thank you.
Thank you. Arbor Woods versus Ashley Irwin.
Sydney Fontanella for the plaintiff, Your Honor.
Hello.
Ashley, oh, there she is. All right.
I am here, sir.
Hello.
Good
All right. She's here. All right. And how much is owing on this?
Your Honor, I'm showing that there's rent due of $1,595.95, court costs of $186 for a total of $1,781.95.
All right. Ms. Irwin, how are you intending on getting that paid?
I would like it. I actually came to see why it's just not the original amount. Hawk just posted a payment to my account on December 9th. Today is the 12th.
Hold on a second. Hold on.
Mhm.
The original amount, you mean the 1846 that was in the complaint, or?
No, I believe that this was for November's rent.
Well, yeah, that's thereabout, but now we're in December, so they can claim December.
Right, but I was waiting for Arbor Woods, and I were both waiting for the payment from Hawk, which wasn't received until December 9th.
Okay, hold on. That tells me something. How much was that payment? Do you know?
It was over $2,000, and I just found out that it was posted yesterday, and that was the 11th, but they've had it since the 9th.
Your Honor, I have the ledger and it was posted on the 9th. The total payment, I can't say that it was from Hawk. I just see a payment was made of $2,032.21 on December 9th. That's on the ledger that I have. And the remaining balance is the $1,781.95.
Right.
Which, when I look at the complaint, is really December.
Correct.
Right,
Okay.
and it's only the 12th. So normally, I'm not speaking for or saying that this is always in writing, but your rent is late after the 5th. Today is the 12th. We already had court papers in, and my judgment.
Okay, ma'am.
Mhm.
They had court papers in because those court papers were filed in November.
Yes, and
Okay.
Matt and Miss
I
Kenyon.
know.
Okay.
All right, I'm just saying this.
Okay.
I don't know that gets us where we need to get to. What we need to do is figure out how we're going to get this paid, right?
Yes, and I am just wondering if we were both waiting, Miss Kenya and I both received an email from Hawk. Her name was Autumn, stating that it would take 3 weeks for the payment. I did not pay on December's because I didn't want to affect anything. I didn't know how much they were paying. So normally my normal rent rate is $16.09. I have the $16.09 and I'm able to pay that. I just don't think that I should be paying court fees and things when we both knew that Hawk was paying, or me and Miss Kenya. And
Well,
I'm
I don't,
requiring fees.
ma'am, I don't know. Well, first of all, I hear you, but I think the problem with that argument is that the plaintiff, Hawk, is going to pay. I don't know when that whole arrangement was made.
November 24th, there was an email sent to Arbor Woods and to both me.
Okay, so
And then
they filed this, but see, so the signing of this complaint was on November 21st. Okay, so they incurred costs because they have to protect their interest.
And Hawk emailed both me and Miss Kenya November 24th saying that they would take care of November's rent, including court fees. So if I was just, my assumption would have been that I'm acquiring court fees. This is for December now, when I was waiting for November to be taken
All right,
care of.
ma'am, what do you want me to do? Because I'm not wiping
I just
out
want to
court
pay my
fees, because
base
I
pay.
think they legitimately incurred them.
I just want to be able to pay the $16.09. They just got their November payment December 9th, and they just posted it in my account. She just said that.
Your Honor,
Okay.
I would object to any waiver of court costs. As Your Honor knows, my client has incurred these fees. They filed this case legitimately. I understand that Hawk has helped Miss Irwin, and that is great. That's been posted on the ledger. Additionally, her rental rate is $16.09, but she also owes water and sewer. So it's not just the $16.09 that she owes. So at this time, I think it's probably appropriate to adjourn at one time since she's appeared. However, if she pays, then we dismiss the case, but it needs to be paid in full, including the court costs.
Are you aware?
I'm in court now.
Ma'am, I'd suggest that you certainly make sure your December rent's paid plus your water fee paid. I don't see a basis upon which I would waive the court fees in this case. But, you know, certainly you're entitled to make that argument to me at a later time, but I'd suggest that you get the December rent and your water, get that paid so that that's what we're fighting about, because right now I've got a 1781.95 balance. I'm going to adjourn this out. I'm going to adjourn this out to December 19th, 2025 at 2 p.m. Ma'am, that is an in-person hearing. You'll need to appear at the courthouse at that time, and then we'll figure out where we go from there.
And if everything is taken care of by then, do I need to appear?
Pardon?
And if everything is taken care of by then, do I still need to appear?
You do not need to appear if everything's taken care of, but that's including the court costs and everything that you are trying to dispute at this point. But if everything is paid, then you don't need to be here.
Right. I'm just trying to make
All right.
sure for which month I'm paying court costs for.
Pardon?
I'm just trying to be clear on which month I'm paying court cost fees for.
Your Honor, there's been one set of court costs that have been assessed.
And those are
What's
for
that?
which month?
They're not on a month. They're by case. You're paying court fees for this case
Okay.
that
I
they filed on
appreciate
the 21st, but didn't even get notification that anything was being paid until the 24th by even what you're saying.
Yes,
So if that's true, which I think that it is, then you're going to owe the court costs.
That's
So
okay.
for this case,
Don't worry about it. I will take care of it. Thank you, Your Honor.
thank you.
Have a wonderful day.
You do the same. Arbor Woods versus Brittany and LaFloria.
Sydney Fontanella for the plaintiff, Your Honor.
I'm here.
Okay, there she is. Okay, I need a camera, ma'am. What is the claim?
Your Honor, this is the non-payment of rent case. I'm showing that there's rent due of $4,158.44, court costs of $186, for a total of $4,344.44 currently due.
All right. Mrs. Floria, how are you intending on getting that paid?
I don't have an issue paying the rent. As you see, I've been going to court with them for a while now. The issue that I'm having is that I keep complaining about certain issues that are happening in a brand new unit that shouldn't be happening. Like I'm having cold air from the outside coming in. And I've been complaining about these for months. So it's like I'm paying them in full because it's like my hand is being forced through court, but then it's like they're not correcting or fixing anything. So
All right. Well, here's what we're gonna do.
They will reach out to their manager.
I'm gonna
because
order.
I guess they are not able to like discount or like credit my account for my inconvenience because I've been having these issues for over a year now.
All right. The issue of escrow in this matter is reserved. Ma'am, you'll need to file a written answer to their complaint with your allegations regarding, I guess, repair issues. You need to do that. I'm going to order that done by the 18th of November.
Okay.
Or 18th of December. December 18th. You need to send a copy to the attorneys. All right. And you need to file a copy with the court.
Okay.
Then I can take a look at what your issues are and what's owing. As I've indicated, the issue of escrow is reserved. I'll order that at some other point. I can't order it at this point. I'll adjourn this matter out.
Yeah, I've just been paying in full this whole time, as you can see.
Pardon?
And nothing is being corrected, so I don't really know what to do at this point.
I didn't hear the first part of what you said.
No, I was saying that over the course of a year, as you can see, I've been coming to court and I've been paying the amount in full, but it's like behind the scenes, they're not correcting the issues that I'm having. So,
all right, that's why I need a written answer, and then we'll attempt to try to see what that's all about.
Okay, thank you.
I'll adjourn this out December 19th, 2025, 2 p.m. And ma'am, that is an in-person hearing, so you'll need to come down to the courthouse. All right, thank you. Arbor Woods versus Tyrone Miller.
Sydney Fontanella for the plaintiff, Your Honor.
How you doing?
Okay, there's Mr. Miller. All right, I'll need a camera, Mr. Miller. What is plaintiff's claim?
Well, I work outside. My phone dropped in the snow, so it's not even working. My camera isn't.
What is plaintiff's claim?
Your Honor, I'm showing that there's rent due of $1,764.82, court costs of $186, for a total of $1,950.82.
Mr. Miller, how are you intending on getting that paid?
So today I'll be paying $823, and then Friday when I get paid again, I'll be paying the remaining balance.
Okay, so you're going to do that today.
Yeah.
On the Friday that you're going to pay the next payment, can you get that paid before 1 o'clock?
Yeah, but I'll get paid usually in the morning around like 8, so I pick my check up and I just go get it.
Okay, so here's what I'm going to do. I'm going to indicate you're going to pay the balance today, or you're going to pay $823 today.
Yep.
And then you're going to get the balance paid by the 19th.
Yep.
So if you get that paid, I don't need to see on the adjourn date. You got to make sure everything's paid.
Oh, it will.
But if you don't have it paid, then you'll need to come down to the courthouse.
Okay.
So I'll adjourn this out to December 19th, 2025 at 2 p.m.
Okay.
All right?
All right, thank you.
Thank you. Court calls the case of Arbor Woods versus David Vaughters.
Sydney Fontanella for the plaintiff, Your Honor.
David Vaughters, they are not checked in. You've been sworn. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There is rent due of $617.72, court costs of $186, for a total of $803.72. And I would request for it to issue in 10 days, which I believe puts us at the 22nd.
Second. Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with writ issue in 10 days. Arbor Woods versus Marjorie Watkins.
Sydney Fontanelle for the plaintiff.
Thought I saw. Marjorie Watkins, not checked in. You may proceed.
Thank you, Your Honor. I am requesting a default judgment in light of the defendant's failure to appear. There is current rent of $617.37, court costs of $186 for a total of $803.37. And I would request writ to issue in 10 days, which would put us at December 22nd.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Arbor Woods versus Michelle Young.
Sydney Fontanelle for the plaintiff.
I'm here.
Where,
I'm here.
there she is. Okay, she wasn't labeled. Gotcha. All right. What is plaintiff's claim in this case?
Your Honor, I'm showing that there is rent currently due of $1,656.47, court costs of $186 for a total of $1,842.47 currently due.
All right. And Ms. Young,
Yes.
how are you going to get this paid?
Can I say something, Your Honor?
Sure.
Okay. First of all, I own that property. It's lot rent that I owe. I've been fixing on that home because I bought it from hoarders. So my hours went down. I'm a nurse, so I'm trying to get help also till I get back on my feet. I just start picking up my hours because I wasn't feeling well. So I plan, but I would like a payment arrangement or get help from Hawk or something. I didn't know anything about it.
Okay, have you called Hawk?
No, I just found out.
Okay,
about
you need to get them called right away.
Okay, can I have a number, please?
Yes, 734-961-1999.
Thank you. I plan on paying them. Like I said, I do own my property. I have to pay them the lot rent. I just have to try to get a payment arrangement to get some kind of assistance.
Well, you can call Hawk. You're always free to call the attorney's office and see if the landlord's willing to work something out for you.
Okay.
All right. But what I'm going to do is I'm going to adjourn this to December 19th, 2025 at 2 p.m. That's an in-person hearing, so you'll need to come down to the courthouse if everything's not paid. All right?
19th?
Yes, ma'am.
Okay, thank you.
Thank you.
All right.
Ms. Fontanelle is asking for you to recall that one. You took a judgment. It should judgment, she said.
Arbor Woods, recalling Arbor Woods versus Flora Boone.
Thank you, Your Honor. Sydney Fontanelle, P86316 for the plaintiff. Your Honor, I had previously taken a default judgment. My client has actually requested to dismiss this case. So I would request to have this case dismissed.
All right, I'll vacate the judgment that I entered. This case is dismissed on plaintiff's motion.
Thank you.
Thank you. Northville Crossing versus Jason Bradley.
Sydney Fontanelle for the plaintiff, Your Honor.
I'm here, Your Honor.
And Makisha Crawford.
She's here.
I'm here, Your Honor.
All right. Oh, they got both of you. Okay. All right. What is plaintiff's claim in this case?
Your Honor, I'm showing that there's rent due of $1,940.06, court costs of $246 for a total of $2,186.06 currently due.
All right. Folks, how are you intending on getting this paid?
Okay, so Your Honor, if I could explain, so the total amount that she's referring to would be, of course, including December's rent, which is would be due the late fee of $50. Now, I do have the amount for November's rent, which is, I believe, $967.29, plus I think the court fees, which would be $1211.29. I can actually have that paid no later than Monday. I just
how much is that you're going to pay?
$1211.29.
$1211.29. Okay, by Monday.
Yes.
Okay. And then what about the balance of that?
Now, the remaining balance, of course, is the $967 for this month. Now, I never received a 7-day notice for that amount as of yet. Normally, it's late after
here's the way it works, sir. You received the amount that you owed in November. Had you paid that, there wouldn't be an issue. But you didn't pay that, so they filed their case. When they come to court, they're entitled to seek whatever's due at that time. And at this time, right now, December is due.
I see. So at this time, I just need a few weeks to get the rest of it because I do work. I'm really the only breadwinner in terms of income. I'm also disabled, so I work from home. But my wife is going to be contacting Hawk today to try to get assistance with that.
Okay. All right. So get the 12/11/29 paid by Monday. What I will do then is I will adjourn this out 1 week to the 19th at 2 p.m. Okay. Also, you can contact the attorney's office and see if there's something that can be worked out regarding, you know, how you're going to get this paid based upon how you get, you yourself get paid. So you can always feel free to do that also. Okay.
Okay.
All right.
Now, I do
Miss
have
Crawford, Miss Crawford, did you want to say anything? He just hogged the whole time that you had.
No, sir.
Did you want to say something?
No, sir.
You're good?
Yeah.
All right. I got sick of listening to him. I wanted to hear
my
from you.
apologies.
All right, folks. That hearing next week is an in-person hearing, okay? So if everything's not paid, you'll have to be here.
Okay. Only myself. I'm sorry, Your Honor. Only myself will be attending that hearing because he's not able.
I got it. I get it. Okay. I understand. Okay. All right.
Thank you so much,
folks. You guys have a great weekend.
Thank you.
Northville Crossing versus Nicholas Buckland and Brittany Moore.
Tepe Fontanella for the plaintiff, Your Honor.
Matter tenant check.
Buckland, Moore, they're not here. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There is current rent due of $720.62, court costs of $246, for a total of $966.62. And I would request for it to issue in 10 days, which would put us at December 22nd.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested. Writ to issue in 10 days. Northville Crossing versus Ardell Carson.
Tepe Fontanella for the plaintiff, Your Honor.
Hello.
Well,
Hello.
okay, there she is. Are you Ardell Carson?
Hi. I'm
Hello.
Ardella, his daughter.
Okay.
My Zoom is not working, so I'm on the phone.
Okay, who are you?
I'm Ardella Gillis, his daughter. I live with him.
Okay. Got it. Okay.
And right now I'm in Lansing. I'm at work at the moment. So I wanted to hurry up and jump on this call.
Okay. I understand. What is plaintiff's claim in this case?
Your Honor, there is rent of $3,895.24, court costs of $190, for a total of $4,085.24 currently.
All right. And ma'am, how are you guys going to get that paid?
$1,100 was already paid on December the 1st. I provided proof to the court. I also filled out a renter's assistance because we filed with our SER and we're waiting on a response, and I have a tracking number.
Okay.
We also
did you file that with the court?
Yes, sir, I did. I sent it to the email that was given to me.
Hang on. Yes, she did. I don't have, you didn't put the tracking number on here, so you may have to refile it with the tracking number by Wednesday. But I have the form you're talking about.
Okay. All right. Yeah, because I did turn in everything that I was supposed to turn in.
Okay. And so, Ms. Fontanella, you have the December 1st payment, I presume.
Yes, I show that $1,100 was received and posted to the ledger on the 1st. And so the amounts that I stated reflect that payment.
All right. And ma'am, how are you going to take care of the balance of this? You got the SER.
Yes, sir.
And I also reached out to Hawk last week, and they said once I get the balance under 3,000, that I can call them back, and they will assist us in helping us with the remainder of the payment.
Okay, but how are you gonna do that with the getting it? Because you need about 1,100 to get that under 3,000.
Yes, sir. I get paid. I just got back to work. That's why I said I'm in Lansing. I work as a home health care aide for an agency, and they just put me back to work on Monday. So I get paid like every 2 weeks. So it'll be the week after next. I get paid on Wednesdays.
All right, here's what I'm gonna do, ma'am. I'm going to adjourn this out to December 19th, 2025 at 2 p.m. All right? And that's an in-person hearing, so somebody will need to be here. And feel free to, certainly, if you get it under that amount, then you can deal with Hawk. We'll need to know the status of your SCR at that time. And you can also feel free to contact the attorney's office to see if something else can be worked out.
Okay, yes, the office has been trying to help us too. So they've been working with us to keep us in the home.
Okay, very good. All right, thank you.
Thank you, sir. Have a great holiday.
You do the same.
Okay, bye-bye.
Northville Crossing versus Justin Hay.
Debbie Fontanella for the plaintiff, Your Honor.
Good morning.
You got him? Yep. Okay. All right, your name, you're Mr. Hay?
Yep.
Okay. What's plaintiff's claim?
Your Honor, I'm showing that there's rent due of $2,242.32, court costs of $190, for a total of $2,432.32 due.
All right, Mr. Hay?
Okay, that's higher than what I was expecting, but that's fine. I'll make a $700 payment Wednesday when I get paid. I just got my heat turned back on. With the cold and everything, that was my main focus. Like I say, Wednesday I'll make a payment, and I'll continue to make those payments until it's paid off. I should have it paid off before the end of the month.
Okay, I can't at this point say that that's going to necessarily work for plaintiff. However, what I will do is I'll adjourn, pay the $700. I'll adjourn this out to the 19th, 2025 at 2 p.m. That's an in-person hearing.
Okay.
And so you'll need to be down at the courthouse. You can also feel free to apply for assistance, but also you can call plaintiff's office and see if something can be worked out by way of a conditional dismissal or otherwise.
Okay.
All right, sir?
Yep.
All right.
Thank you.
Northville Crossing versus Brenda.
Good morning, Mr. Jones.
Good morning.
Miss Mowat, I know you were connected to a criminal case.
Yes, sir.
As a victim. Which case are you here on in landlord-tenant court? Do you have a case today?
Oh, it was Ronnie Miller.
Oh, Ronnie Miller's criminal case was yesterday afternoon. He's not set for anything in my court this morning. I set him for sentencing. Let me look. I don't know if it's in the calendar yet. Who gave you a notice to be here this morning?
I'm sorry?
Oh, how did you get notice to be here this morning?
I have a court, or I have court with the park, the trailer park.
Oh, okay. All right. So
It's
you're
not
in Memory
related
Lanes
to
also.
that.
Okay.
Yeah.
All right, got you. I got you. We're letting the clock tick a little bit.
Okay.
It is 9 o'clock. I'm gonna go ahead and start the record. Our first matter is Jessica and Jeffrey Wilder and the estate of Cheryl and Wilder versus Tara Ann Hendricks. The file number is 252402. Mr. Dutka is present with Jeffrey Wilder.
Jessica is here.
Is Jessica there too? Jessica, good morning to you.
There she is.
Oh, good morning.
Field of vision leaves something to be desired here.
All right, well, she looks better than he does, so I'm not sure why you got him there rather than her, but we'll just do the best we can. We had a previous case with Miss Hendricks, 25717 LT, before their mother passed away. And we went through a quite involved case, and eventually it was, I believe, dropped. I disclosed at that time that I know Jessica and Jeffrey Wilder. Their grandma lived 2 doors away from me. I was friends with their father for 50 years, and I've watched them grow up since they were little kids. Now Jessica lives 2 doors away from me. But despite all that, I don't feel that I need to disqualify myself in this matter. Having said all that, Jessica or Jeffrey, do either of you have a problem with me handling this matter?
No, Your Honor.
No, we do not.
All right. Is Miss Hendricks gone? Is she out of there?
Well, Your Honor, we're not sure. She never turned in the keys. And I note the deputy did serve her at an address in Sturgis, not only for the notice to quit, but also the summons and complaint.
Yeah.
But she had other hangers on and other occupants with her, so we honestly don't know how many sets of keys are out there, and we don't know, if anybody is still in there. That's the bottom line.
Well, I didn't know. She was personally served. Let's make sure she's not here. Hello, Deputy Kending. I'm looking for a Tara Hendricks.
I haven't seen anybody here by that name.
All right, thank you. Bye. Checked in. So she is subject to default. Was filed as to Tara Ann Hendricks and all other occupants. And the judgment doesn't have that in there, but I'm going to write it in there. Oh, and yes, it does. I find by default, plaintiff has a right to recover possession of the property. Jeffrey and Jessica, Mr. Dudka knows this, but I have to give 10 days. So 10 days from today would be December 22nd. No money judgment is entered at this time. Does she still have property there?
Well, that's still another unknown. We thought, and I don't know, Jeff could jump in on this one anyway, but because he lives not far. But anyhow, that was another thing. We're not sure about that, and it's some cause for concern as far as liability is concerned.
Your Honor, I decided to keep my distance from the house and away from her. She's a really volatile person. I mean,
I'm sorry, I can't hear you very well.
I try to avoid that property right now because she is a very volatile person and she's into violence. I just didn't see the reason to exacerbate anything.
All right, well, Mr. Dutka will give you good counsel. After 10 days, you can ask for a writ of eviction and the sheriff can come put her stuff out. I believe your intention is to put this house up for sale, but you need to make sure that you've got her out of there and you're doing it the right way. You don't want to go in there and get a fist fight or a shouting match. So I respect the choices that you're making here, but you're doing it through the court. I find that Tara Hendrick and any all other occupants in that property at 624 Elm Street,
Wrong.
excuse me, 475 South Baroque Road.
Yeah.
I don't want to evict you from your own house.
Yeah.
475 South Baroque Road are subject to termination of tenancy 10 days from today. Now, there's always concerns at this time of year whether the heat is on. You don't want the pipes to freeze. You do have my authority to inspect the premises.
That's good.
That could be catastrophic. It's about to get real cold, like -2. I would suggest that maybe you ask the Colon PD or go over there and see and make sure that there's heat on in the place. What is the source of heat?
Gas or?
I believe it's electric, Your Honor.
Electric heat's very expensive, but at least the electricity is probably hooked up anyway. You have my authority to inspect the premises prior to the eviction date to make sure there's heat in the property. All right, Mr. Dutka, thank you for your help and thank you for helping them.
Well,
we've taken a little extra time to see whether she showed up, and she did not. I think she's out of there, but we'll make sure.
Well, I appreciate that. Thanks, Your Honor, very much.
All right, best of luck. Thank you.
Thank you, Your Honor.
Thank you. All right, we've got several memory lanes cases. And Mr. Jones's case isn't actually until 10 o'clock. Jump ahead, but we're not there. Miss Mowat, your name doesn't appear on here. Who are you with? I've got Kelly Bice.
Today is
Brittany
12th.
Holtz.
Today's the 12th, correct?
Today's the 12th.
Yeah. I have my court papers here. Where would I find?
Well, I'll take a look at it. Good morning, Mr. Jones. I don't show your case until 10 o'clock. Your mic's on mute.
Yeah.
There we go.
I'm just waiting my turn, Your Honor. I'm
All right.
not used to this setup. I had to have my son-in-law come over and get stuff going for me, so.
Well, Garrett was here last time. Let me check on Miss Mowat's case, see what the
Okay.
deal is.
You want my case number?
I'll share it, see if we match. Give me a minute here.
Okay.
Well, I'm in the wrong thing. You got some unpaid tickets you're gonna need to take care of, but let me.
Okay.
Yeah, it shows it at Memory Lane's mobile home at 9:10.
Yes, sir.
And so you're in the right place. Elaine, I don't have the Memory Lanes versus Autumn Moat file. Shows it's on here, but I don't have it.
I'm here, Your Honor. It should be on the agenda.
It is. She's here. It shows it's set for 9:10, and I don't have the file. Let me make sure I didn't clip it to my last file, which I've been known to do. I've got it right here. I did clip it to my last file. So Elaine, I found it right in front of me. Mr. Stuart Weiner is here on behalf of the park. Let's see who else is here.
Yeah.
Chris Corpening, their manager, I believe. All right, Miss Mowat is the only one here, so I guess we'll just start with advising her of her rights as a tenant.
Okay.
And we may have to do this more than once. Good morning, Miss Corpening.
Good morning, Your Honor. Good morning, Stuart.
Ms. Mowat, they have filed a motion to terminate your tenancy. I want you to move.
Yes.
As a defendant in such a proceeding, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to assist you. They're usually with us for these proceedings, but our legal aid attorney, I believe, is on vacation. So you have the number to contact legal aid, or you could seek other legal advice. You have a right to have the case. Say that again.
Where would I find the contact information?
It should be in with your summons and complaint.
Okay.
Anyway, we'll make sure that you find it.
Yeah.
Okay. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use the jury demand form and pay the $50 fee unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted from property because you haven't paid rent, that is a different circumstance. In this case, they're simply asking you to move. They wish to terminate your tenancy. You may be able to reach an agreement with the landlord by going through mediation, or you may be able to reach an agreement with the landlord that means the case will get dismissed, in which case they could file what's known as a conditional order of dismissal.
Okay.
They are moving to terminate your tenancy. They served that notice to quit on you on August 18th. Is this lot and trailer?
I own the trailer.
All right, so this is a screwy one. Mr. Weiner, what's your position here?
So, Your Honor, and I have Ms. Sharpening here to answer any further questions. Apparently, there was an agreement to rent the lot, and have possession, but she did not identify another person who was living with her. That created the first problem. She violated the agreement that she had signed for her tenancy. And then this person has created problems in the park. Police have been called on a number of occasions, and we have received multiple tenant complaints. So I think Ms. Sharpening tried to address this issue with the tenant, but to no satisfaction. And so we have to regrettably.
Is that person Ronnie Lee Miller?
Yes, Your Honor.
He's in jail right now for assaulting Miss Mowat. or he was, maybe just got out on a bond. Anyway, he's charged with assaulting Miss Mowat, and he is set for sentencing in the near future. Miss Mowat, what's your position?
On, I'm unaware, on my position on what, Your Honor?
Well, they want you to move your trailer and go.
Yeah,
They're evicting your trailer. And the one difficulty is there's nowhere to move a trailer to.
yeah.
So what's your position?
I am not sure. I was thinking about if it did come, like if they, if it was a moving situation, then I would have to sell it because the trailer is rather old. And it has some structural problems, so I don't think I would be able to move it.
It is an option in the just cause termination. It says you have 10 days to sell or move the mobile home.
Yes,
And
sir.
most of our currently cited mobile homes are not movable.
Yeah,
A, they're not movable, and B, there isn't anywhere to move them to.
yeah,
But because of these incidents with your boyfriend, they're wishing to terminate your tenancy. So you're getting a double whammy. I think he was charged with stalking and domestic assault.
yes, sir.
And now because of him, they want you to move.
Yes.
He currently has a bond condition that he's not allowed to have any contact with you.
Yeah.
Ms. Corpening and or Mr. Weiner, does that affect your position, knowing that the source of the problem has been charged with crimes against her?
I doubt that, Your Honor. Ms. Sharpening, what do you think?
Well, I never had a problem with Autumn in the past until Ronnie moved in. I'm willing to look at it and have a conversation with Miss Mowat. As long as he's not coming back, I'm willing to consider that.
Okay.
But he can't come back. He's created a real problem in the mobile home community.
Yes, sir.
Well, he did 30 days jail. And he's on a probation with some jail hung over his head. No contact with victim until further order of the court. All right. Well, let's continue this a bit to give you an opportunity to discuss this. He has been released from jail within the last day or two after doing 30 days. He's on probation. And one of the conditions of his probation is he's not allowed to have any contact with Miss Mowat.
Does that include telephone calls or just physical contact, Your Honor?
No contact whatsoever.
Okay.
All right, Miss Mowat, who else lives there? Do you have kids there?
Yes, that's me and my daughter, or me and my two kids.
Well, we're coming into the holiday season, so we've got some missed court dates. But we are available next Friday, the 19th. We're probably going to continue all these till next Friday, Mr. Weiner.
Okay.
So let's see how that works for you. The 19th.
Let me check. The 19th works for me, Your Honor.
For the day is crammed full. 10:30.
Okay. I can be available.
Ms. Mowat, I would suggest you've got a couple options. You may contact legal aid. There may be some defenses to termination of tenancy when you're a domestic violence victim.
Yeah.
There may also be able to set up an agreement with the park that if he's not there, that you can stay, in which case they could work out something called a conditional order of dismissal. So I would suggest that you contact Ms. Corpening and discuss that with her.
Okay.
Now, Ronnie's not supposed to have any contact with you, and if he does, he's in violation of the probation. So don't let the camel get his nose under the tent. Don't let him call you. Don't let him stop over there. A, it violates his probation, and B, it's going to ensure that you get evicted.
Yeah.
Stop in today or early next week and talk to Ms. Corpening about this, and then she can discuss it further with Mr. Weiner.
Okay.
All right, thank you. You're good to go.
Thank you so much.
Okay, thank you, Ron.
All right, we've got Brittany Holtz and Moto G Stylus. Who is Moto G Stylus? Good morning. Who am I speaking with?
It's Kelly Bice.
Okay, Kelly,
can you do something more than telephone?
What was that?
Can you turn your camera on?
Yeah. Is that better?
There you go. Very good. Good morning to you. We've got two more Memory Lanes cases. Attorney Stuart Weiner is here on behalf of Memory Lanes and their matter. Chris Corpening is here. 252531 is Memory Lanes versus Kelly Bice, and 252433 is Memory Lanes versus Brittany Holtz. Both tenants are here, and these are both non-payment of rent cases. Good morning.
Morning.
Who are you looking for?
I was just looking for Paul.
Paul Gibson?
Yeah.
He's not in here. He might be on the other side.
Well, he went back here. He said he was going to talk to the prosecutor.
Judge Patterson's got everything in his court next door. So you're in the right, just wait out in the hall. He'll come out and find you.
I think.
All right, ladies, you're both here as tenants in a non-payment of rent case. They want you to pay your rent or move. Let's talk about that. In that kind of case, you have a right to obtain counsel for representation in this matter. If you cannot afford an attorney, legal aid attorney may be able to assist you, and they're not here with us today, but you do have their number in your packet of information. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance or file a written demand within 5 days and pay the $50 jury demand fee. If your landlord is asking you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, that's DHS, local coordinated agency, that's Community Action Agency, Housing Assessment and Resource Agency. I understand that that is Neighborhoods, Inc., and they've simply recently gone through a restructuring. Not sure what their current status is. Or federal help for homeless veterans if you're a veteran and you're eligible for veterans' rights. You do not need a judgment against you to get assistance from the places listed above. A copy of the summons and complaint are sufficient despite what DHS may tell you. You may be able to reach an agreement with the landlord by going through mediation or community dispute resolution. If both parties are interested in that, the court can help set it up. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case we could have something prepared called a conditional order of dismissal. So the first case actually said is Ms. Bice. Ms. Bice, they contend that your rent is behind and they want you to pay the rent or be prepared to move. Is this lot only or lot and trailer? It's $975 per month, so I believe it's lot and trailer. Is that correct, Ms. Corpening?
Yes, it is, Your Honor.
All right, so this is like renting a house.
Mhm.
Mr. Weiner, what's the current arrearage?
So the current arrearage is $6,006.20, and let me break that down. In the complaint, we asked for, at that point in time, there was an arrearage of a July balance, August, September, and October. And with late fees and pet fees, the total was $3,650. Then November and December, rent was not paid. That brought it to $5,300 for just the home and the lot, late fees of $300, pet fees of $150, and filing fee of $130, process fees of $51.20 for process of service, and $75 for attorney fees. The total amount of all of that is $6,006.20. That's due and owing through December.
Excuse me, Stuart, she did make a payment.
Oh, she did. That's right.
We'll
That's
address that in a minute. Let me,
Okay.
130 plus 5120 plus 75 equals 256. That's not right. 130 plus 5120 plus 75 equals 256.20.
correct. Those are the costs.
All right, Ms. Corpening, how much has defendant paid?
She has paid $950.
So we'll subtract 5,300 rent minus 950. Well, I'll tell you what, I'm gonna put rent, pet, and late all together, which is 5,300 plus 300 late plus 150. Pet fee is 5,750. Minus 950 equals $4,800.
Correct, Your Honor.
All right, plus 256.20 equals 5,056.20. Ms. Bice, what's your plan? Do you wish to stay there, or do you think you're gonna move?
I'm gonna stay here because the trailer is paid off, but they're still charging me the rent. The math is not correct. Like me and Chris went over it, and it's just supposed to be lot rent.
So you're alleging that the number isn't wrong because they're still charging you a payment on the trailer after you've paid it off?
Correct.
Do you have the title to the trailer?
No.
I do not.
Ms. Corpening, what can you tell us about that?
Her July payment is her final payment, but it's not paid as of today. It's not complete, and her tax and title fees have not been paid. So therefore, that is why we continued charging the way we did, because none of that has been finished paid. Now, if she pays that off, we will be happy to just charge her that lot rent with the late fees and not charge her the full payment.
All right. So you got a commitment here. You actually bought this trailer.
Correct.
So you need to go see Ms. Corpening, and maybe that $950 should have been applied to those costs rather than rent. You need to pay the July payment and some other title fees, and then the trailer will be in your name and they could adjust the amount.
That's what we're gonna go over today when I go in there to pay her some more money.
All right. I'm gonna continue this to 10:50 on next Friday, December 19th.
Okay.
I get a weird compunction at the end of the year to try to finish everything before we go into the next calendar year. There's a real necessity to it. We can adjourn it further, but it sounds like you got a plan. If you can get that paid off, she could reduce this to lot rent, and even then they could work on something to get it paid. So you're gonna meet with Ms. Corpening. We're gonna discuss this further, and I will see you next Friday morning, December 19th at 10:50 by Zoom, just like this. Okay? Do you have any questions?
No, I just got so behind because of life. Gave me lemons.
Yes, I see it each week. Life is full of surprises, and some of them aren't good ones. All right, I'll see you next week, and we'll see how we're doing.
All right, thank you so much.
All right, thank you. Next is Memory Lane Mobile Home Park versus Brittany Holtz. File number is 252432LT. This is a similar situation. We had a case previously. This one is also appears to be lot and trailer. What's the current status, Mr. Weiner?
In this one, Brittany Holtz owes for September, October, November, and December. So she owes $3,900 for October through December in lot and home, late fees of $200, pet fees of $100, filing fee of $130, process service fees of $51.20, and attorney fees of $75, totaling $4,456.20.
Once again, the costs are $256.20.
Correct.
Ms. Holtz, what's your circumstance here?
I did make a payment. I've made a couple payments. I did make a payment of $500, and then I did make another payment of $1,060. So the total should be down now.
Just a minute. Are those payments reflected here? When did you make those?
I made one of them yesterday, and I made one of them like a month ago.
Well, the one yesterday, I'm not aware of. Chris, are you aware of the one a month ago?
Yes, Stuart, I sent it to you in your email, but you were busy yesterday.
Oh, okay.
Yes, she did make a payment of $1,060. I do have without court costs, her total right now is $2,640.
Okay, that's a lot better.
Mm-hmm.
All right, so $2,640, and if we take another $500 off of that, it would make it even less.
No, that does
So-
include the $500, Your Honor.
It
I
includes the
did take that
500?
off. I did take that off, yes, sir.
All right, so, all right, $2,640.
Yes.
So $3,900. All right.
So Chris, the number of 2,640, does that include the late fees, pet fees, filing fee, process, and attorney fees?
It includes the late fees, the pet fees, no court fees. So that $256.20 would be added to the $2,640.
Okay.
Well, if we subtract it just from the rent, 3,900 minus 1,560. We get a rent figure of 2,340. And then if we add 200 late and 300 or 100 pet, we get her figure. 2,640.
Right.
Plus 256.20.
$2,896.20.
2,896.20. All right, Ms. Holtz, that's not an insurmountable amount. Let's talk about what happens next. The law says I need to adjourn this at least 7 days. So we're going to continue this to next Friday, 12/19/26 at 10:55. We're going to be real busy there for a while. And even then, if you don't pay the entire amount, you get 10 additional days to pay the rent or you're being subject to being evicted. Even if you don't pay that, they still have 56 days from that day to ask for the rent. So is your plan to try to catch up the rent?
It is.
Are you going to ask for any help?
I actually did apply for some help through DHS and I did get approved for that, totaling $1,040. And I just submitted, they wanted me to pay a certain amount. So I did submit to them the receipts of that payment. I have not heard back from them yesterday, so I'm not sure where they are in processing that, but
Well,
that
let's
should
talk
be
about
helpful.
that. Let's say that they give you $1,040. That would be good. The only thing that'll cure this is paying the entire amount. A partial payment does not cure the writ of eviction, but we'll see where we are next week. We can continue it further, I suppose, even if we need to. We're still in the month of December. But for now, you share this information with DHS. You owe $2,640 in rent, late fees, and pet fees, plus $256 in costs. So the total is $2,896.20. On January 1st, another $975 is going to be due, plus the pet fee of $25. So it's $1,000 will be due on January 1st. All right. Do you have any questions?
I do not.
All right. My advice is always stay in contact with your manager, stay in contact with DHS. We'll revisit this next Friday morning at 10:55.
Okay, sounds good. Thank you.
About, depending on how backed up we get. All right. Mr. Weiner, I think that's all of your cases for this morning.
It is, Your Honor, and I appreciate that.
All right, Ms. Corpening, we'll see you next. Thank you.
Thank you, Your Honor. Thank you, Stuart.
All right, take care.
Ms. Bainbridge, could you join me?
I'm here.
Good morning.
Good morning.
This is file 252484. It's entitled Bobby Joe Bainbridge versus David Green. We never got off the dime. Mr. Green has not been serviced and served, and Miss Bainbridge has not paid the sheriff for his service. Is Mr. Green gone?
No, Mr. Green has agreed to leave on, he had asked if I would, originally he wasn't going to leave. And then he asked if I would give him until the end of January. And I have agreed to give him till the end of January. But I was advised to move forward.
All right, well, I don't have the authority to do anything. He hasn't been served. He isn't here, and you haven't paid the process server's fee. So I'm simply going to show that this matter is dismissed If he doesn't move by January, you can rebring the case.
Now if he, with it being, I had actually, made contact with, Bruce, and he was going to serve, and I had provided the payment information. So I'm kind of confused on why he wasn't served, but I also did do the mailing, the certificate of mailing, and returned that back to you. And then I actually handed it over to him, and we had the discussion yesterday, but obviously that would be my word against his.
All right, well, so I guess what we can do is, there's a lot of back and forth between you and Sergeant Morse.
Yes.
So do you wish to continue the case to actually get an order?
Yes.
Is your car moving?
No, I'm sorry. That was me bobbing my head. No, it's not moving. I'm not in the passenger seat.
All right, well, I'm going to continue this 2 weeks for service. And you're going to need to pay him for the service. Now, it could be assessed against the other party, but this is a termination of tenancy action, not a non-payment of rent. So let's see where we are in 2 weeks. All right, I'm going to set this for 2/15 to December 29th at 2:15.
Okay.
Ms. Bainbridge, it probably makes sense to go through with this. Well, we need to get service and you need to pay for it.
Okay. I'll follow back up with Bruce.
Then, if we, let's say we work an agreement that he agrees to move by January 31st. If he doesn't move, then you can get the writ of eviction. Without doing this, if he agrees to move and he doesn't move, then you have to start all over again. So I think we should stay on the horse we're on, get service, get notice to him, and get an order in place that protects you. The clerk had some concerns for your safety. Is everything okay there? Can you stay there for a month and a half?
Yeah. I mean, it's my home. I mean, he's staying at my house, so.
Yeah, he's at your house and you want him to move and he doesn't want to move.
Right.
He's not paying rent, correct?
Right. Well, he's not paying, correct. I mean, we never have had a signed contract for a rent. We were in a relationship.
Yes, so what he is now is a tenant at sufferance. So he's living there without benefit of a lease and you want him to go. And ultimately, it's your right to do that, but we got to follow the steps.
Okay.
So we're going to continue this for 17 days to December 29th. We'll get service on the defendant and have further hearing.
Okay.
So, all right, I'm glad you were able to be here. I told the clerk she needs to be here so we can deal with this.
Okay.
All right, so we're going to continue it. We're going to get an order. And then if he doesn't leave, you'll have the authority of the court to have the sheriff put him out in an eviction.
Okay. Perfect.
All right, you get back to work. I'll see you on the 29th. You stay in contact with our clerk and with Bruce Morse.
Okay, thank you. I very much appreciate your time.
All right, well, that's why I'm here. Thank you.
Thank you.
All right, we're plugging away here. Miss Roberts, can you hear me?
Yes.
That matter is set for 9:40. It's now 9:45. We're doing pretty well. This is an odd case. This is Shannon Roberts versus Michael Roberts, which is file number 252485. Mr. Roberts and Shannon Roberts are married. When he got married, he changed his name to Roberts. This is at the plaintiff's house at 47485 Haynes Road. If I understand correctly, Ms. Roberts, he's not even actually living there.
No, he hasn't lived here for 2 years, but his address, his mailing address, and the address on his license is still here.
All right, if I do evict him, I'm not sure that that would change anything.
Well,
Where is he
supposedly-
staying?
Well, supposedly, I don't know. Supposedly, the Monday before Thanksgiving, he left and went out to the Dakotas. I've had eyewitnesses telephone me and tell me that, yes, he's in the Dakotas. I have people that reside with me still that have contact with him almost daily. They keep saying he's coming back. I don't know where he's at.
All right, well, are you divorced from him?
Yes, we've been divorced since November 8th of 2023. He knew what he was doing by not changing his address because I have no legal recourse. When he comes here and things come up missing, I can't do anything because legally it shows he lives here. When my nephew
All right,
Larry
so he-
Roberts,
Go ahead.
when my nephew Larry was living here, he too is on probation. So Mike wasn't supposed to be here at all. He was well aware of that. He would show up unannounced. He would come right into my house. I changed locks. I changed codes. My nephew tried to get a PPO. He threatens people that are here that stand between me and him. So he, when he can't
Well, it
help me
says
or
here
whatever.
He was personally served. He is not there. He does have family in the Dakotas. He's in one of the tribes. I think he's got reservation rights. I'm not exactly clear what the Living Good family was.
He's
I
a
know
member
there's
of the Turtle Mountain Chippewa band that's in Belcourt, but he's either in Fargo or Sioux Falls, South Dakota, or Fargo, North Dakota. That's where his two brothers are, his remaining family.
All right, well, he isn't here. He was personally served. You are divorced. He has no lease, and he has 10 days to vacate or subject to being evicted.
I can't believe anything he tells me. He tells me he changed his address to Sioux Falls, South Dakota, yet there's nothing on his SOR report. It still shows Floating Bridge Road, where he was also evicted from.
Well, I don't know this is going to solve your problem. It will give him no right to come back to your house, but I don't know that it'll change his driver's license or his address. But you filed a motion to terminate the tenancy. It was personally served on him before he left on November 17th. And I think maybe it's best for him that he go back to the Dakotas where he's got family. But I've signed the order. He's subject to eviction after. Does he have any stuff there?
No. He took everything the day that he signed the papers in the courthouse for the divorce. Last I knew, he was living in the back of his truck, but now he's texted me and told me he gave his truck to his brother and his brother crashed it. So I don't know. You can't believe anything that comes out of his mouth. So I don't know.
Well, I've given you what you asked for. He was personally served. He is not here. He's subject to eviction. 10 days, you can ask for a writ of eviction. You really don't need to do anything. He doesn't have anything there. But this will establish that this Haynes Road address is not his lawful address.
And that will show if he shows up again.
Is that a Haynes Road? I thought your address was South Fisher Lake Road.
No, that's where I grew up. I live in my grandma and grandpa's old house, which is on Haynes Road, 57485 Haynes Road.
All right. Who's in the brick house?
My brother Joseph.
Oh, I thought you were still in there. Okay.
No, Joe's there and mom's house was gone in land contract to the Krotzers and I have grandma's old house.
Okay. I gave you what you asked for. 10 days, he's subject to being evicted. That's not his lawful residence.
All right.
All right.
Thank you
Good
so
luck.
much.
Okay.
All right. Bye-bye.
Bye. All right, we have one remaining matter. Mr. Jones is patiently waiting. The matter is set for 10 o'clock, so we have to let the clock tick a little bit. I'll remove Shannon Roberts from here. Mr. Jones, I'm going to take these files out and I'll be back. We have to wait until 10. I don't expect anyone's going to show up at your hearing, but I'll be back here in 9 minutes. I'm going to take these files out to the clerk.
Yes, we can hear that.
What's your last name? Menard.
So what are we doing?
Menard, yes, sir.
What are we gonna do here?
He's gonna take he's gonna 18 months.
That's what
Is there any restitution still?
I think there is, but I don't know that for a fact since it's been so long.
So I need. It's like restitution was $2,000 back in 2016.
I would say it's probably there still, Judge, because this is a situation where he never reported, so.
Oh, he's never reported since 2016?
That's right.
$1,956 restitution.
Are you able to pay that, sir? 1,000, that's the restitution to these people.
Yes, sir. And short time, yes, sir.
No, I'm going to take your word for it. You absconded 8 years, over 9 years ago, almost a decade. Is that right? You absconded, you took off, you flew. You were supposed to report in 2016 to the jail and you never did? Is that right?
He did do 120 days up front.
He did do that, yes.
Okay. When was it? What is the period of time that he has been?
From his release there on.
Which is what date? So we're accurate on.
Yes, sir.
It was in February of 2016.
I'm sorry?
February of 2016, sir.
Oh, okay. February. All right. So that's going on 10 years. In a couple of months, right?
He was actually released from Jefferson County on June 8th, 2016.
Okay.
I believe that's what you were asking.
The last time we saw him was June for his.
He was supposed to come for intake, but he never showed up for intake once he was released from the jail.
Okay. And it's been almost 10 years since his release.
Yes.
And he never, okay.
9.5 years.
And so he was placed on probation in February of 2016. But so he must have been in court somewhere in February of 16. That was the last time we had a contact with him?
That was the date you sentenced him for this, Your Honor.
That was the last face-to-face contact we had with him until he was arrested recently.
He was arrested when? About?
In Harris County in October. He did have fun.
10/25. Okay. Really, at the end of the day, he's been an absconder, took off for a decade. All right. So this is a state jail felony, right? I guess.
Yes, sir.
And he hasn't paid anything to these poor people, and he has nothing to pay.
He stated that he has he's getting Social Security, I believe, and that's how he was able to live.
Do you have the ability to do the investigation?
Here's what I'm going to say. No on this deal. He gets 2 years, as far as I'm concerned. He gets 2 years. I mean, what, really? He took off for a decade? I mean, why isn't this one of those where you get the max? What message do we send if he doesn't get a max? If 5,000 people on my docket took off, and then when they came back, they're going to say, I want the Trumba rule. He didn't, I don't want to get severely punished here, even though I walked off the job and didn't pay anything. And for a decade, y'all had to find me. Okay, I got found. Now I'm going to make a deal. No, that's not the message I send. We've got him. We got a hold of him. He's going 2 years, and he's going to go do the full 2 years, as far as I'm concerned. That's it. Now, you don't have to agree to it. We'll just set it for a hearing. That's what we'll do. But he's not getting. Are you kidding me? I feel sorry for the poor victims who hadn't gotten a dime since you fled. The message we would send is, yeah, do all of this, flee. If you get caught in a decade, we'll make a deal. No, I'm not going to do that.
Well, just so that the court's aware, and I don't know how, he did make phone calls, and I think Mr. Menard would confirm this initially from Harris County saying, I need to transfer my probation to Harris County. He was unable to get back to Jefferson County to actually report. He informed the probation officer of that. It wasn't Mr. Menard, of that fact, and he tried to work with it, but apparently the state didn't really care about it that much and let it go. And so clearly they haven't thought too much about it. Well, I mean, 10 years.
Okay. But it was the court's order. And we're talking about the court's orders. Y'all are working things on the side, and that didn't work. That's not important to me as the court's orders that have to be followed. And sometimes they can't be, but then I get the court, and somebody comes to the court. It was my orders that we made based upon our hearings and what evidence was presented in due process. But these side deals, that's not as important to me after I made my order. I need to be in the loop. Y'all I know y'all are trying to work things out, but this is atrocious. I mean, really, anybody who sees this goes, you can flee, you can flee if you get caught in a decade. You don't have to pay your restitution back. We're going to make a deal of whatever it was. Y'all going to make I don't know. What was the deal?
18 months.
Yeah, 18. Yeah. And
I'm not asking you to approve it, Judge, but I do want you to know that I got to that number because in that 10 years, there was not a new criminal offense. And again,
every day he's committing a crime.
Yes, sir. And Judge, I love your philosophy on this. I'm not disagreeing with it at all. My thought is in that 9.5 years, if he actually wanted to report, he could have made it here. I'm in the same boat with you in that regard.
Well,
when they come to me,
it's good for everybody. I set a standard by what I do. It's what the people say, is it fair or not? But in your circumstance, you had more than enough time in a decade to take care of this business on your own. We had to get you.
Yes, sir.
And sorry, there is nothing but bad on this. There's nothing good. It's all bad. And then the poor victim, if I was the victim, I go, okay, so he's going to get some time. He doesn't get maxed for being gone fleeing for a decade and hiding out and then being caught. But then I'm out $2,000 and he didn't even have to pay that. That doesn't seem wrong.
We can be ready whenever you want to set it for a hearing, Judge.
Yeah, I'm sorry, Mr. Trumba. That plan is not fair. And what's fair is what you have done is whatever the law, whatever is extreme under these situations, you deserve it because that's what you did here. You deserve the maximum. And it wouldn't be fair to everybody if you didn't. I'm not going to let set a standard where you can flee for a decade, not pay anything back, and then come in and make a deal of something less than what the statute maximum was. Now, if you can find a way to pay these people back quickly, well, you're not going anywhere, but I never let you out. But if you can get somebody to help to pay this back, I will reconsider this whole thing.
Okay.
I will, because I want these people paid back. And that's another equation that you're going to get a deal and for all of this, it's no.
It's a payment, right?
So do you have any contacts, anybody who might be able to help you on this?
Yes, sir. Yes.
Okay. Why don't I then reset it a week and see what, I don't know if that's going to be enough time, but I can reset it a week.
Enough time to.
I can reset it for any length of time, but you're not leaving anywhere until this gets done and these people get accommodated. And then I'll be willing to go forward with the plan. But
how long do you need, Mr. Chairman?
Might be a little longer.
What's a little like? Give it.
Why don't we bring you back next week and see where you are in everything?
Okay. Review then, Judge?
Yes, sir.
Okay.
All right. Reset it.
Come back in.
Well,
Okay. There should be Mr. Paget, Mr. Wilkerson, Ms. Holmes, Mr. Eckert, Alex Comerford, and then pro se people. Where's everybody?
Mr. Wilson sent us an email this morning. He was ill and wouldn't be here. Wanted to reset his case. Ms. Holmes' case.
Okay, please bring Joseph Castillo out and we'll tell him why he's not having his hearing.
Brittany Holmes, that case was reset because they just filed a first amended MTRP. So they have to have time. That Mr. Comer called in, said he's running about an hour behind. And I haven't heard from Mr. Patrick.
Paget's here somewhere.
Okay, all of these, let's reset them for a week. Okay, because these are dispositions. I don't want to go to the holidays.
And Mr. Eckert is here. I think he's in the back of compliance.
Oh, yes. So Castillo, I'll do it for a week on Wilkerson's deal. Let's see. And you said Comerford's on his way.
Comerford is running an hour behind. Apparently it's flying in and they're waiting on the visibility for the pilot. So.
Okay. Who are you?
Justice, yeah.
I'm sorry.
Justice, yeah. Steve.
Wilkerson's got.
Okay, Marcus Wilkerson is unable to be here, but we're going to reset this just until next week so we can figure out what's going to happen. This is an MTRP hearing, and I want to dispose of this one way or the other before the holidays. So we're going to have to reset for next week, okay? Thanks, Mr. Christie.
Still sending this in the back to this one. We get it out of the end of
Thank you.
Oh, I was mean.
Oh, this is, yeah. We gotta do that. Bring it
We're in a short recess.
And then there's also an issue on the other case that I need to address. haven't had access to. There was an issue with discovery in the system where it would only allow me to look at the front page on one of the cases. So I went upstairs before I came here, and Ms. Mayfield was fixing that issue for me. So on the hindering apprehension case, the 3rd degree. So I need to review that one. But we haven't from the.
What's taking so long?
Well, first of all,
I don't see.
First of all, I was just hired on this case a short time. So there's no holdup on my end, Your Honor.
I understand. I don't see it on your certificate. I don't see one announcement here.
That's right.
But this thing's.
So I've been working until you got.
2 years and 3 months old.
It may be that she was. Maybe that she was out on. I'm not sure.
Did you move or something?
Yes, sir.
Yeah, that's what.
So I'm working. We're not stalling here at all. We've worked out the theft case.
Come on out.
Come on. The hindering apprehension case to this morning, all I need is 30 days. This will be,
you got it.
This will be taken care of.
We said 4 weeks.
Neither one of us are looking to drag this out.
Thanks. I was just, the question was, for 2 years and 3 months, what happened when that
She's in,
had one announcement out, all that.
She has taken herself out of this environment here. She's going to college in Middleton right now.
I was just curious about the whites who dropped the ball on that, but they just couldn't find it.
But I assure you, we're not going to trouble.
Yeah,
I've got the ball now.
Yeah. Yeah, we said 4 weeks. Thank you.
I'll carry the ball across the finish line here. How about that? Torch. Something like that. You want a torch ball, whatever you want to call it.
All right. Shannon Ardwan, tell me about this one. Sister Pam. Can I bring the defendant out, I guess? The process.
What I'm telling you is, we'll come back here.
Where we're at with him is we're in the discovery process.
There's no more stalling.
He's been given all the written discovery.
Make the trip back.
And we're in the process of the media discovery. And Sonny had, when he had the case, broke it down and he got.
He's not representing him personally, but this guy's representing himself.
He's representing himself, and he's had 2 days where we reviewed a bunch of media. And I've got proof about that. Hang on, Judge, before we bring him out, I just want to let you know, I've got to get upstairs and get another thumb drive with media so that he can review that. Right now,
how's he doing that? How's he doing that?
It's got to be set up where
the thumb drive, and then it's in the jail. They make something available.
No, sir.
You have to do it here.
Yes, sir.
Okay,
that's my understanding. I sure would make it a lot easier if there was a different way to do it, but I understand he's been reviewing it in the jury room.
Okay, do I need to bring him out right now?
I'm just asking, let me get what I'm gonna have available for him to review today before we bring him in.
Let's do this.
I can't, I do want to cover when he's on the record what he's seen as far as in May. There was an opportunity there he was given to review some documents in July, but that thumb drive didn't open up. So that's why we're trying to make sure I've got it in a position where he can take care of it. Give me 2 through. We gotta do anything?
I don't think we need to bring him out. Do you want to bring him out?
What are we doing?
It's still gonna be a trial.
Okay. Yeah, yes. Puente.
Once I'm done with this, I'll get that stuff from Mr. Ardwan.
All right, then we call 25 CR 263, the state of Texas versus, we haven't, hold on. Versus, is it Danielle Carmona Puente? Yes. All right. And Mr. Puente does not speak English fluently. All right, so we have an interpreter here. And please tell us your full name, ma'am, for the record. I know you, and then I've got to swear you in so that as an interpreter for this hearing.
Yes, sir. Erica Birch.
And we know Ms. Birch as a fluent interpreter, speaks fluent English and Spanish. Raise your right hand. Do you solemnly swear or affirm you will properly and correctly translate English to Spanish, that the language your client understands, that Mr. Puente understands? You will repeat his statements of Spanish into English for the record. You will do that correctly. So help you God.
Yes, sir.
All right, Lois. All right, go ahead.
Judge, we previously had this case set for trial.
Then why did we take it all?
I asked for it to be set today so that I can speak with him.
Okay.
In an effort to figure out where he's at on the case and whether or not there was any conviction possible.
Okay. He's charged with burglary of a habitation, which carries with it up to 20 years in prison if convicted. And where are we on the attempts to resolve it without a trial?
Mr. Ham has made an offer of a deferred adjudication probation.
And he's not accepting that.
Correct, Judge.
Okay, and that is odd. The court will generally, defendants closely consider deferred or unadjudicated probation since those are not readily given as an opportunity, and deferred is something where the defendant will not be found guilty so long as he follows terms and conditions of probation. Most of those terms and conditions of probation are the rules that all of us have to follow, like don't commit a crime and don't become intoxicated and don't take care of your personal business and your family. Those are rules that we all are required to follow. So when somebody turns down deferred or unadjudicated probation, that's rare. I'm just curious, what is the reason he would do that? Now, he certainly has a right to a jury trial. That's what the Constitution stands for. But deferred or unadjudicated probation also allows a defendant to be released in 1/3 of the time of probation if the defendant does well, and that's what the court does regularly. And I don't know if he knows that or not, because if it was 10 years probation, he could be released in 3 1/3 years and move on with his life if he did well.
So we were able to talk about all that today, Judge. And I can say that we have thoroughly considered it. In this case, I do believe that there are issues suggesting factual innocence.
Okay, well, if he goes to trial, he doesn't get deferred or unadjudicated probation by a jury. That's not allowed.
He understands that.
And they would either acquit him or convict him. And if he's convicted, he could go to prison for up to 20 years. If they grant probation, it's a conviction. And it is seldom erased.
Yes, sir.
When you were finally convicted. He understands all of that.
Yes, sir.
You understand all of that. Okay, then this, as long as he intelligently and voluntarily weighs the issues, it's his life. He can make the decision he wants, and we will set this for trial and try to get this as soon as we can get to it. Okay.
Thank you, Judge.
That's what we will do. And there are no, I won't accept a deferred or unadjudicated probation offer after today. So,
I understand.
okay, we're going to trial and that's the choice he makes. And he won't be, the court will not allow deferred or unadjudicated probation if he turns it down today. Okay.
Yes, sir.
Thank you. That is all.
Thank you.
Next.
This is, I think this is an actual. Already found ways. There was an, I looked at that for you to review some things in July.
July 17.
And I've actually looked at that deal and it's a bad copy. So what I had attempted to do today was to get some more material ready for you to review. And as the judge explained, the mistake was made and they recopied some of the stuff you've already seen. All right, so I can correct that. I can have that done, and judge is being gracious enough to explain it and allowing me to do it.
Can you get it to Mr. Ardoin?
I can do it, and
it's Tuesday.
I can have it ready next week. The problem is going to be that availability for him to review it, and it's, I believe,
during the trial.
Correct.
We're going to be having a trial, but we'll figure it out.
Okay,
we'll figure it out.
I've got some good checklists, and I'll go over it with you.
What does it take for him? Where does he need to be? I'm
my understanding
fuzzy about how this is practically working.
We've been doing it in the jury.
We need the jury room.
Yes, sir, but we have to have somebody in there with.
We need to
understand.
That's what
the logistics.
we're not.
Well,
they're different than what we're used to.
We probably won't need the jury in the jury room until Wednesday or Thursday.
So in theory, Judge, if you've got a jury trial going on out here, you won't have the security be able to be with him in there to do that.
Have an extra person available to help on this.
That might be doubtful, Judge.
Yeah.
We could try.
Trust. Can we see what we can do? Thanks.
If nothing else, we'll have to down weeks.
My goal is to get this information to this man next week.
The jail, is there any kind of way to group you in the jail? No one's there.
Not really.
Monday and Tuesday is going to be impossible unless the DA provides their own officer. But Monday and Tuesday is going to be impossible for us because we're already.
What about Wednesday?
Wednesday and Thursday are probably more split.
Can we try to work on Wednesday? Work it out for Wednesday. Okay, I'm going to set him to come back up on Wednesday, and we're going to get it done one way or the other next week. But that sounds like the earliest.
The only problem with that would be is if the trial is if it's a quick trial, then you might have to deliberate by Wednesday, Thursday.
We don't know until Monday which trial out of the group.
If we set it, and if we are at a point where we do not have the
Let's set
ability of the room,
I want to bring him in Wednesday so we can know one way or the other, and then
yes, sir.
We'll get it next week somehow.
May I ask him one more question, Judge? Yes, so when Mr. Eckhart was working on it and you reviewed it those 2 days, did you see that, what he called a media sheet?
I have one.
All right. So, okay, good. So you've seen and you know what you've seen and not seen.
Yes.
Good.
You know what
I wanted to make sure.
You know how that works. That media sheet.
And I'm gonna I'm working on a copy to make that available for the court's record too. So good. Big screen. Thank you.
I know in the past they have done bring the media to the jail and did it there.
Well, let's figure out. I've told him he's going to get it next week. So let's figure out how we can do it.
That would be best convenience because they have these.
We're just going to get the jail on board what we're doing here right now. It's not.
Yeah.
Well,
We need to talk to them out there, get the captains involved, and maybe the sheriff, and get them to step up, because they're not doing it right now.
Okay, all right.
I'll let them say.
They do have the room for that, as well as for the legal research, access to courts.
What is that room? Is that what that room is normally used for?
No, it's normally used for arraignment.
Okay, so it's on,
When it has
when it's not being arraigned, it's free.
Right.
When there's not arraignments there. Oh, bunch. All right, well, we'll bring him back Wednesday, see, hopefully. We'll start that we can get it, but our goal is to get it done next week. Okay, thank you. Yes.
What's the? Hold up.
And we've got Alex Comerford on Jadarius Hamilton we're waiting on, right?
We're an hour behind.
What is the plan on this? Do you know, on this case? It says an announcement. I mean, he's going to fly in to say trial and then fly out, I guess?
Judge, you may want to call the defendant too. He's on bond.
Oh, that's a good point. Hey, Dennis, can you call Jadarius Hamilton? Should be outside. And ask him to come in. Please. Okay. So these. I don't know. I'm sure there's something about people. Next year. Sounds like he's there. Oh, yeah. This. Okay, 25 CR 769 is called State of Texas versus Jadarius Christopher Hamilton. That's you?
Yes, sir.
Okay. And Alec Comerford is your attorney.
Yeah, he seems running late.
He is running late. And
I was here at 8. He's still not here.
He's running late. And it's going to probably be another 10 or 15 minutes. So, so stand by. Okay. All right. So, just stay close by because you're the last one left here on this docket, and we need to know which direction all of this is going to go in. But just stay close by outside. Yes, sir.
And good morning, folks. My apologies. We had a little bit of technical difficulty. Court does call the case of Blue Heron Point versus Roderick Casey.
Good morning, Your Honor. Nasreen Hammoud, appearing on behalf of plaintiff and standing in for the attorney of record.
Good morning.
All right, Roderick Casey. Okay, there you are.
Good morning. I'm Sharon Lee. I'm Roderick Casey's mother.
Yeah. Is Mr. Casey here?
No, I apologize. He's not. He's in the hospital.
Oh, he is?
Yes, I did email a letter from University Hospital.
Yes. Oh my gosh. Okay. And counsel, I will have my staff send you the letter. I don't know that I want to necessarily broadcast the procedure here. It's significant. How much is owing this time?
At this point, Your Honor, there's an outstanding balance of $8,475.
Ma'am, let me ask this. He is not going to be out anytime soon.
No, he did have another procedure last night.
Yeah, it was last night that this occurred.
No,
he had the surgery on November 2nd, but he did have another procedure last night.
I
So
got
I'm
you.
not-
Let me just do this. He'd be entitled to the adjournment anyway. So I'm going to adjourn this out to the 19th, December 19th, 2025 at 1 p.m. And what I'm going to do so that we don't go through everything, because I'm not sure how to analyze all of this. Council will send this over to you for the consideration on everything. Okay.
Thank you, Your Honor.
All right. And that's, yeah, it's listed as an in-person hearing, but of course we'll make whatever accommodations we need to make. All right.
Okay.
Okay.
Thanks.
And Ms. Casey, best to you and your family. All
All
right.
right, thank you, Miss Lee, not Miss Casey, but thank you.
I'm sorry. They didn't put the name up. They usually do. So I just said, okay, I'll use that name. All right.
Okay, thank you.
Best to you and your family.
Thank
Take
you.
care.
Bye-bye.
Bye-bye. I need,
A letter to council.
to council. Legends, Rosewood Village versus Alyssa Worley.
Thank you, Your Honor. Jackie Snyder Powder for the plaintiff.
Do we have Alyssa Worley? Oh, there she is.
You need to unmute, Miss Morley.
Sorry. Good morning.
All right. Okay, very good. What is plaintiff's claim in this case?
Rent to retain of $5,346, court cost of $179.50 for a total of $5,525.50.
All right. And ma'am, how are you intending on getting this paid?
I did inform Lisa from the office that I could make what was stated in the paperwork, which was 2,673 today. I also did inform her that the remaining balance will be paid, or December will be paid by so I wrote all this down so I didn't forget, December 26th.
Okay, so you have the 2673 now?
Yes.
All right. So here's what I'm going to do. You're entitled to an adjournment. And so I'm going to indicate in my file that the 2673 that you're going to pay by Monday. Okay.
Would I be paying that towards the court, or would I be bringing a cashier's check to the office? Sorry, I just don't want to do it.
You can pay it directly to their office.
Okay.
Okay, directly to the landlord. So
Thank
pay
you.
that amount to them. And
Yes,
then
sir.
I'm going to adjourn this out to December 19th, 2025 at 1 p.m. That's an in-person hearing.
Yes, sir.
But what I'm going to suggest you do is contact the plaintiff's counsel's office, see what arrangements you can make regarding the payment of the balance.
Okay. And so you did say adjourned until December 19th at 1 p.m. in person?
Yes, ma'am. And that is an in-person hearing.
Yes, sir. Thank you.
All right. Thank you.
Happy holidays.
All right. You too.
Thank you, Your Honor.
Thank you. New Park Ridge Apartments versus Jonathan Smith.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
Jonathan Smith. They are not here. If you'd like to be sworn.
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, this is an action for non-payment of rent. The rent to retain possession is $441, court costs of $176 for a total redemption of $617. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested with a writ to issue in 10 days. And I think that's it for you. All
Yes.
right. And because of your office retreat, let the others in your office know that the two will take care of the afternoon.
Okay.
All right.
All right. Okay. Thank you, Your Honor.
Thank you. Pine to Clover Lane versus Kennedy Callaway. And Lucas, is it Resendi?
Good morning, Your Honor. Jen Wilburn, P83143 for plaintiff.
All right. And I think Lucas is here. Sir, your name?
Lucas Resende.
All right. And what is plaintiff's claim?
Your Honor, it looks like Kennedy Calloway is here as
Yeah,
well.
you're right. I do see that now.
Yes,
Kennedy
I'm here.
Calloway, you're here? Okay.
Yes, I am.
I do need a camera if you got it, but let's go ahead.
Judge, this is a non-payment of rent case. I show a balance $2,820.71, court costs $214, grand total $3,034.71.
All right. And folks, how are you intending on getting that paid?
Well, I mean, I'll be honest. So my side of the story. So we broke up a few back in like July and whatnot months ago, and I haven't been living there for the past like 5-6 months. So I've been focused on surviving. Really, I've been homeless. I was without a car. Had to use the last of my money to get my car, and then I crashed my car less than 24 hours after buying it. So I had to work to get my money, get my car back together. And then I lost my job after that. So right now I'm jobless, homeless. Right now I got my car trying to keep it afloat, and whatever last money I got right now, I'm trying to use to move across the country. Yeah.
Right.
Yeah, I'm in a pickle right now. I ain't gonna lie. I don't really.
I got you. Yeah. We lost Miss Calloway. We lost Calloway, didn't we?
Yes, she dropped.
You dropped off.
Uh-oh.
All right, here's what I'm gonna do, because Miss Calloway dropped off and they'd be entitled to an adjournment anyway. Oh, she might be coming back. Hold on. Hello, is that Miss Calloway? Okay, you'll need to unmute.
I do apologize. For some reason, I was removed from the meeting and I had to re-enter.
That's okay. All right. Did you hear the balance that's owed?
I did not. I got the
Okay.
for that.
The total amount, including court costs, is $3,034.71.
Okay.
Okay. So my question that I had asked, and Mr. Renzende was describing his circumstances. I understand that there may have been a breakup here, whatever happened, but that you're in the unit.
Yes, I've been the only one occupying the unit and paying the rental payment since August.
Okay. So how do you intend to get this amount paid?
Firstly, I was not aware that the balance was that high. I was prepared for the 1,963 that was originally put on the court summons. I did attempt to pay 1,000 of that 2 days ago, but they were unable to accept a partial payment.
Okay. So how much do you have? How much do you have now?
Presently, I have $1,000 in a money order made out to them.
All right. And you can pay that to them by Monday?
Yeah, if they're willing, if they can accept the money order.
I'll handle that part. You
Okay,
have
yeah,
$1,000.
I do. It's in my wallet.
All right.
I
Then
can drop it
what
off.
you need to do is take the $1,000 to the landlord. I'm going to order the landlord to accept the $1,000. Okay? They'll take it.
Okay.
And then how are you intending on clearing the balance?
Well, based on our previous conversations, Lucas and I, it doesn't seem as though he has an intention to pay and that I will be paying it all myself. If that does seem to be the case, I would likely need until if
All right, ma'am. Have you reached out to Hawk or any other place for assistance?
No, I've just been working 6 days a week for the last 4 months, trying to put the money together the best I can.
I gotcha. Okay. So here's what I want you to do. Did you see the video that was played?
I did not.
Okay.
Oh,
All
I'm
right.
sorry. At the beginning, yes, I did with the rights and everything. I did.
Okay.
Yes.
So the Hawk or SOS, did you get that phone number?
Yes.
it's also in your paperwork. I'm going to suggest that you give them a call and see if they can provide any type of assistance for you.
Okay,
All right. And also there is available, although it wouldn't be much, there's only one person in the unit now.
yes,
So you could also apply for an SER or state emergency relief. But for you, the maximum would be $410, but that's about 1/4 of what you're gonna have left. So it's not, or, I guess less than 1/4, about 20% of what you're gonna have left after you pay the $1,000. Okay? So I suggest that you do that. If you do the SER or contact Hawk, the rental assistance form that is also in the packet that you received with this summons, you'll need to fill out that form and file it with the court by Wednesday.
okay,
Got that?
yes, sir.
All right. So I'm going to give you an opportunity to call Hawk, apply if you want for an SER. I'm going to adjourn this out to December 19th, 2025 at 12 noon. And that is an in-person hearing, ma'am. So if everything's not paid, you need to show up at the courthouse.
Okay, yes, sir.
All right. Thank you, folks.
Thank you.
Thank you. Pines of Clover Lane versus Michael Lambrecht.
Hello, Your Honor. Good morning.
Good morning.
And
Your
again,
name?
Jen Wilburn,
Oh, go ahead.
P3143 for plaintiff.
All right. Your name, sir?
Michael Lambrecht.
Okay. And how much is owing on this?
Right now, outstanding rent, $2,843.48. Court costs they show is $175, total $3,018.48.
All right. Sir, how do you intend on getting that paid?
Well, Your Honor, to be honest, I wasn't aware of the total amount owed. I was just on a phone call several days ago with the office, and they told me it was under $2,000. So this amount is surprising to me. However,
Well, and that may have been the case if you were calling in November.
no, sir. I was calling just a few days ago here in December.
Okay. Well, that's the balance that the attorneys have, and quite frankly, let me just see. Well,
This was to do with both a late fee attached to the rent amount due, as well as court fees, I understand it, for them applying to their attorney to file the case. This is what I understand.
I had at the end of November or in November, I had 1,500. Your rental rate's about 1,100, which would have brought me up to about 26, right? Yeah, and then you would have had late fees and then court costs. So the figure is in the ballpark, quite frankly, and I'm just ballparking the figures
Oh, this is
myself.
for 2 months due.
Pardon? Yeah, see, your November and your December.
Okay, this sounds about right.
Okay, so how do you intend on getting that paid?
Well, sir, I am doing my best to get it paid. I understand that there's going to be a case for my eviction regardless. I'm going to do my best to get it paid. I am currently full-time employed. I've looked for a second job, have been accepted for a second job. However, this second job has decided to go under renovations. This was for the, if you're familiar, the worst bar of Ypsilanti. They have recently renovated and decided to rebrand. And so I have not had the chance to earn a second paycheck from that second job. So,
all right. So here's what I'm going to do, sir. And what I'm going to suggest that you do is I'm going to adjourn this out to the 19th of December, 2025 at 12 noon. That's an in-person hearing. You'll have to appear at the courthouse if this is not paid. I'm going to suggest that maybe either you apply for some type of assistance if that would be appropriate for you, or that what you do is you contact plaintiff's counsel's office to see if something can be worked out.
I understand. Thank you.
All right. Thank you.
Thank you.
Thanks, Judge. And I believe all of our others were dismissals.
Yeah, let me just make sure. Pines of Clover Lane versus Handel, Pines of Clover Lane versus Jasper, Pines of Clover Lane versus Beach. Those cases are dismissed on plaintiff's motion without prejudice, and I don't see any of them here. Okay.
Thank you,
Take
Judge.
care.
You and your staff have a good weekend.
You do the same.
Thank you.
Group 5 Management versus Edith Castello. That matter is dismissed on plaintiff's motion without prejudice. And then 899 Ridge LLC versus Samir Darwaze.
Good morning, Your Honor. For the record, Neil Chanis appearing on behalf of the plaintiff.
Waze, we do not have them. If you'd like to raise your right hand to be sworn, I'll let you take a default. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead, sir.
Thank you, Your Honor. We are moving for a default judgment for possession only. We show that there is rent owing of $1,190, costs including statutory attorney fees of $175, for a total possession judgment in the amount of $1,365, with the writ to issue after December 22nd if that amount remains unpaid.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your
All
Honor.
right.
Have a good weekend.
You do the same, sir. And I think that's it for us. I don't know, he was been here, but
We just call this case.
okay. It was a dismissal. Oh, he's gone now. Okay. All right. That's it. That's for the morning. Everybody take care. We will then be reappearing at this afternoon sometime. And thank you to the friend of the court.
Next matter is Cynthia Burns and Joshua Higley. That's filed 12-14492-DS. Go ahead.
Same circumstance, this hearing was adjourned. This is an arrears only case with the request of $113. The arrears balance is $1,933.74. Payment was received for that amount in October and November, so we are just requesting the same.
Granted. Lindsay Budka and Josh Higley, file 17-16932-DS. Go ahead on that one too.
This case was adjourned as well. This case does have a monthly obligation. He was requested to pay $249 monthly. The sum is composed of $166 for current support and $83 for overdue. The arrears balance on this case is $15,416.97. Since the hearing, $249 was received in October. $100 was received in November, but the same circumstances, that additional payment of the $149 was received on 12/1, so we would just request to adjourn as well.
Granted. Carissa Mager and Joshua Higley, file 18-17318-DS. Go ahead.
Same circumstance for this case. This is a currently charging case with a request of $159 monthly. The sum's composed of $106 for current support and $53 towards overdue. The arrears balance is $2,392.36. Since the hearing, payments that accumulated that were made as well, and just requesting to adjourn.
Granted. Levette Peel Poll versus Joshua Higley, file 24-19573-DS.
This case is similar. This is a currently charging case with the support obligation of $258. Sum is composed of $172 for current support and $86 towards overdue support. The overdue balance on this case is $2,175.58. Payments were received accumulating that amount in October and November as well, and would just request to adjourn.
Granted as well. Mr. Higley, looks like you're doing what you're supposed to be doing on all of your files. I appreciate that. Thank you very much. We're going to simply adjourn these out again, kind of just monitor, and as long as you're making your payments, they'll keep being adjourned. At some point, the friend of the court will say, let's adjourn it for a longer period of time, and then we'll just watch and see what you do. So keep doing what you're doing. Everything's good. Do you have any questions for me?
No, Your Honor.
All right. Thank you very much. You're free to go today.
Thank you.
If the jail schedule bring this break over to, sir.
I don't think so.
No, we don't need that. Ms. Kraus, I think that you had some special requests on the Brink matter. I know that she's not here, but I think we just want to make a record of that. Can we do that next?
Sure.
Let me call those cases then.
Oh, her attorney did just pop on, Larry Brown.
Mr. Brown, are you here on that?
I'm sorry, Judge, what case is that?
Chelsea Brink.
Yes, Your Honor.
There's two of them. Let me find them and call both of them if I can. I only see one on here.
Your Honor, I do believe Tara is here. I would be specifically on the case with Mr. Hildebrandt, but Tara, I believe, is also here from friend of the court.
Yeah, that's the William Mason case.
Yes.
Well, I can't find that one on my computer, but let me call it anyway. This is William Mason versus Chelsea Brink, file 13-15199-DC. And we also have Mr. Devin Hildebrandt versus Chelsea Brink, 11-14050. I believe that your requests are going to be similar, so it doesn't matter to me which one does it, but if you just remind me what your request is.
Yep, the request would be in regards to that the plaintiff is still being lodged and is still currently lodged in the Otsego County Jail since November 8th. She does have current support on both cases. Friend of the court is actually requesting direction from the court on how to proceed as the plaintiff is still lodged and is facing other criminal matters.
All right. I'm aware that Ms. Brink has both probate and criminal matters. It appears to me that she's going to be incarcerated, has been incarcerated, and is going to be incarcerated for a substantial amount of time. I'm simply going to ask the friend of the court not to enforce any action on the child support matters at this time. We'll set it for a review hearing in approximately 3 months to find out where she's at and begin any enforcement if necessary at that time. Is that sufficient for your needs, Ms. Kraus and Ms. Spillane?
Yes, so just no enforcement, not abating support as to it may be over the 6 months, or we can address that at the next hearing.
I'd like to do that. If you could mark down, I believe you've already got it in your file as to when she began her incarceration. And at the review hearing in 3 months, we'll take up whether or not she remains incarcerated. And that would be close to the time period of the 6 months for the abatement. So if you could make notes in both of your files as to review abatement for 6 months, and we'll see whether she is incarcerated that long. I anticipate she may be, but I don't know that for sure. And so I'd rather be sure before we actually do the abatement. So we'll just stop enforcement at this moment until we figure out a little bit more information on that. Any other questions that you have?
I do not, thank you.
All right, thank you very much. Should be on me. They both should be.
I haven't marked it both.
There's Brink.
And then go down, there's a Brink down for me. Right there, go back up, right there. Down,
Oh,
right there.
it's a Hildebrandt. All right, I see that right now. All right. Well,
That's okay.
yeah, it'll live. Thank you. All right, I'm going to call all of the Brewer matters together as well. So I'm not sure. I'm not sure if we have any 915 Brewers or not.
No, we should not.
All right. I'm going to call Mr. Brewer's. Is Mr. Brewer with us? Apparently not.
You have a Tim Brewer.
All right.
Ask him to unmute.
Mr. Brewer, if you would put your video on and unmute yourself, please.
Yeah, I'm trying, Honor.
All right. Thank you, sir.
There we go. Oh. Morning, Your Honor.
Morning. Find the one that needs to be called first. All right, I have Kaylee Jaraneski and Timothy Brewer. File 24-19758-DS. Ms. Kraus, let me know what's happening with this file, please.
This hearing was adjourned from September 26 to monitor the medical status and payments. The defendant was to submit medical documentation to the friend of the court the same day of the hearing regarding his surgery from September 24th. This was not done. The defendant did present yesterday to make a $200 payment that is still pending, and it may disperse as how it does, but I'm not able to tell you as to how it will disperse to the 3 cases. I did receive an email after contact yesterday regarding his surgery. It simply said he had surgery and would be out of work for 6 weeks, but there was no additional information. So that should give him coverage through October, the week of October 16th. I haven't had any correspondence with him up until yesterday. The obligation for this specific case is $342 and arrears of $3,043.91. I do believe, based on our conversation yesterday, that he is doing some subcontracting work that he started this week.
Brewer, what's going on?
Oh, well, Your Honor, I just, number one, that the doctor's note I turned in, I realized it gave 6 weeks. I did get a quite bad infection from that surgery. I'm sure if I need to contact the doctor and get something else, I'm sure he can probably write something up. During that time, my pickup, which is what I use to plow, I have 90 plow accounts that I have plowed every winter for about, I don't know, about 7 years, but my pickup burned to the ground. I had just took full coverage insurance off it. So that kind of put a spin into my life as far as work. I used my pickup to plow with and to tow my tractor around, which I do a lot of work. As I told Ms. Kraus yesterday, I did just take a job with His and More, subcontracting to them, doing roadside repair and snow plowing. I guess I just set that up Monday. So.
Your Honor.
Well, yes, go ahead.
Part of the requirement from the last support enforcement was to update the friend of the court on the status of the medical conditions as they change and provide that information. He just indicated that he has 90 type jobs that he had done last year. Through the winter months. Well, this specific case entered in July of 24. There was a payment of $31.39 in December, January, $62.79 of this year, and then March of $31.31. So if he's plowing those over the winter, there hadn't been payments made.
Mr. Brewer? What's going on? Why aren't you paying?
Was that last winter?
Yep.
Your Honor, last winter I had that quite so.
You're breaking up, Mr. Brewer. I'm not able to hear you.
I got it. Yep.
I haven't heard a single thing that you said, Mr. Brewer.
Can you hear me now?
I can now.
Can you hear me now?
Yes. Can't now.
I don't know if you can hear me now. I can walk outside here. Last winner.
You're cutting in and out and your picture's frozen. Now I can see you a little bit better. You're frozen again and I can't hear you.
That helps. Can you hear me now,
Can you hear
Yana?
me, Mr.? I can hear you now.
All right, let's see if I can stand right here.
So the friend of the court said, if you've got 90 plowing jobs, why didn't you make more than just a few minor payments last winter?
Oh, I can't recall, Your Honor. I do believe I went through a divorce and I moved out.
If you're going to keep walking around, I'm never going to hear
some
you.
time. I didn't move, Your Honor. Well, maybe I did a little bit.
The camera hasn't stopped moving yet.
Well, I guess I'm trying to. I'm right here in the same room, trying to get service, Your Honor.
Stand right there and don't move.
Yes, sir.
So let's back up. First of all, the last court order was that you submit medical documentation to the friend of the court the day of that hearing, which was December the 12th. You didn't do that.
All right.
You sent an email later. The next requirement was that you obtain and return the completed physician's form regarding your disability to the friend of the court. Ms. Kraus, did he do that?
No, that was not done.
The next requirement was that you update the friend of the court on the status of your medical condition as it changes and provide corresponding documents. You sent one email and didn't send any information on this infection. Why aren't you following through with the court's requirements?
Your Honor, I was never asked to. What was the part before that? You said I was required to fill out some type of paper for that evaluation paper.
Obtain and return the completed physician's form regarding disability to the friend of the court.
I do not recall any of that, Your Honor.
It's in black and white on the order that was entered.
Okay. Well, then that would be my mistake.
That's why we send these things out to you, so you don't have to try to remember them. They're in black and white. So how long is it going to take you to get me this information from your doctor on your infection?
Oh, I should be able to do so next week. I will do so next week, Your Honor.
Good idea.
First part of it.
I want it to the friend of the court's office by the 16th. That's Tuesday.
Yes, Your Honor.
You got the rest of today, the weekend, and Monday and Tuesday to get something to the friend of the court's office by 4:30 when they close. The physician's form regarding disability. So when you bring that information to the friend of the court's office, Ms. Kraus, was that form sent to him already once?
It was, but he on the record indicated that day he was bringing
to arrest or to solve problems where I see fit in my duties as a law enforcement officer.
And were you working in that capacity back on November 19th of this year?
Yes,
Did you respond to any calls that day?
I did.
Did you respond to a call at 6329 South Washington?
I did.
Where city-wise is that located? Is city, county, et cetera?
It's in Lansing over on the south side.
The city of Lansing, though?
Yes, yeah,
That's in Ingham County, right?
correct, yes.
What was the general nature of that call?
The original response for that was a possible domestic fight between the victim, who was the mother of the accused.
And when you arrived, did you make contact with anyone?
I did. I made contact with the victim right in the drive.
Do you remember the victim's name?
I can't. I believe it was Marjorie. I can't remember the last name right off my head.
Okay. And you indicated what was the relationship with the accused?
That was his mother.
And did she indicate to you if they had lived together or not? Was there any other type of relationship there?
Yes. So she's told me that he's been living with her his entire life, and they've been living together at that house on Washington for approximately 1 year.
And where did you speak with her?
Right in the driveway.
At the time that you spoke with her, how did she appear?
I would say she was a little shaken up. I guess concerned about the situation that had occurred.
Did you physically see any injuries or marks on her body?
I did.
And what were those?
So she did have a red mark on her left wrist, and she explained to me how that red mark ended up with her.
And how did she explain that had happened?
I'm going to object, Your Honor, to request for hearsay statements at this time.
Do you want to respond? Your Honor, as I indicated previously, I am intending to proceed under 27C. Officer Shading has already testified that they do qualify for a domestic relationship, as they did live together and had lived at this particular address for a year together. Based on the call for service, he had responded shortly after the incident had occurred, which indicates that it was trustworthy at the time that he received the statement. Your Honor, objections overruled. You can continue. Again, officer, did she indicate to you how that red mark had happened on her wrist?
Yes, so she told me that the accused, Mr. LaPearl, was in the kitchen and he was making breakfast. At that time, she did tell me that he had a GPS tether on. And because of that GPS tether, he needed to attend court. While he was making breakfast, she told me that she asked him about going to court. He refused and instead he began arguing with her over this, and this argument escalated to a point where Mr. LaPearl grabbed onto her left hand and began twisting her wrist. The victim told Mr. LaPearl multiple times to stop, and he refused. And the victim had to physically pull her arm or pull her hand away from Mr. LaPearl in order to get him to stop.
And did she indicate to you if that was the end of their interaction or if something else had happened?
No, so after that, when she pulled her hand away from him, from the accused, she said that she was going to call the police. And after that, she doesn't remember exactly what Mr. LaPearl said in reference to that, but she believes he said something along the lines of, don't call the police, something along those lines. At that point, Mr. LaPearl grabbed the phone out of her, I believe it was her right hand, and he threw it onto the kitchen floor.
Did she indicate if the phone was damaged or not at that time?
It was not. I inspected the phone myself.
And then did the victim in this matter indicate to you when she was able to call the police successfully?
After she exited the residence and went outside.
And did you have contact with the individual that Ms. Stoinski indicated had caused this to
Yes.
her? Do you see that individual in the courtroom today?
I do.
Can you point him out for me and describe something that he's wearing?
He is on the left side of the table and he is wearing a blue in-kind jumpsuit.
Your Honor, I would ask that the record reflect the identification of the defendant.
No objection.
Identification is noted.
And I apologize. I know you were telling me quite a bit all at once. I just want to make sure I heard you correctly. Did you
Yes.
say Ms. Joynsky indicated to the defendant that she was going to call the police, or that was just her intention?
No, she said directly to Mr. LaPearl that she was going to call the police.
I have no further questions. Thank you.
Cross-examination.
Thank you, Your Honor. Officer Shady, first of all, did Ms. Swinsky require any type of medical treatment?
No, I asked her if she needed medical attention and she declined.
Okay, and you saw a red spot, but nothing beyond it, correct?
Correct.
And then you said that you inspected a phone and she claimed to you that he had thrown this phone down on was it a hardwood floor?
It was.
And this phone showed no damage when you looked at it, correct? And you stated that she was still able to call 911 as well.
She was, because she had a separate phone.
Okay. But she was able to call the police
Yes.
shortly thereafter. Where was Mr. LaPearl when you arrived, Johnson?
He was down in the basement.
Okay, so he was still at this residence?
Correct.
So after she was calling 911, he did not flee the scene. Is that fair to say?
Correct, yes.
And is it also fair to say that, I don't know, did you look up the fact that he didn't actually have court that morning as well?
I did not look that up.
Okay. Would that have made a difference to you if you known that she was essentially giving a false statement regarding his court schedule on that day?
I don't believe so, no.
Okay. Thank you, Your Honor. No further questions at this time.
Can you read it?
No, Your Honor. Thank you.
Thank you, Officer Shady.
Thank you.
No, Your Honor. The people rest.
I'm sorry, the defense calling any witnesses.
No, Your Honor. The defense is not planning on.
All right, go ahead.
Thank you, Your Honor. I believe the court heard the, albeit brief, testimony provided by Officer Shading under 76827C, providing the victim statement in this matter. I'm first going to address count 2, which is a crime of interference with an electronic communication. The victim indicated to Officer Shading, who testified today, that she intended to call the police and that the defendant prevented her from initially doing so. The amount of time that he prevents that does not have to be a significant amount of time, only that he was aware she was trying to have some kind of communication and he prevented that. Turn then to count 1, which is interfering with a crime report, which has a long subset to that of committing a crime, threatening to kill, injure, or causing property damage. The way that it is charged, Your Honor, is that he did commit an assault or an attempted malicious destruction of property. However, based on Officer Shading's testimony of the victim's statement, I would ask that that be changed to interfering with electronic communication, meaning that the defendant did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime, that being the domestic violence incident that Officer Shading testified she was attempting to report, and that violation involved committing or attempting to commit count 2, which is the interference with electronic communication. I think based on Officer Shading's testimony of the victim's statement, I have met all of my elements, at least to a probable cause standard, and I would ask that you bind them over. Thank you.
Your Honor, I guess if I could get some clear, I guess I don't understand what you're still asking for all 3 counts, and count 1, you're just changing
the crime that was committed.
Okay, all right. Thank you, Your Honor. Your Honor, while the court did find that it was appropriate to hear the testimony through 768.27C, one of the elements of that statute are that the statements are trustworthy. I would argue they're not based on some of the testimony we heard today. We heard testimony about a court date that did not occur. We heard testimony of a phone allegedly being thrown down.
You said a court date that did not occur?
Yes, he stated that.
I recognize there was testimony that there was supposed a question, I guess, an inquiry from the alleged victim about a court date, but how do we know that the court date isn't?
Well, I mean, the court could take judicial notice that he
I don't know where the court date was. Was it here?
He had a matter that was going on but he did not have any court dates. I do represent him on another matter.
Okay, well.
I guess I can't put myself. in
Whether
the
it
seat.
happened or not, whether the court date happened or not, doesn't necessarily make the matter or make the issue not trustworthy, right? Because the issue was that there was an inquiry as to whether or not there was court.
No, it was my understanding that he testified that she was trying to get him up and going because he had a court date that day.
Okay, that could have been her belief, right?
And right, and that's one factor. She also claimed that he threw her phone down on a hardwood floor and that the officer testified there was zero damage done to that phone. I find that to be difficult to believe if somebody threw it down that hard.
Maybe there was an auto box on it, I don't know.
Well, there's possibilities, but I think that goes to the trustworthiness of her statements, Your Honor. So we would ask the court to, based on that, and the fact that she was able to call the police in this matter, right in the same vicinity. So I would ask that the court deny bind over on counts 1 and 2 in this matter for those reasons. Thank you.
Any argument at all?
Briefly, Your Honor, first, Officer Sadie testified that she indicated to him that she questioned the defendant as to whether he was going to court or not. It doesn't indicate to me whether or not that court date occurred. I don't think that necessarily indicates that her statement is not trustworthy. Additionally, Your Honor, as the court is aware, most people have cases on their phone. The fact that the phone did not result in damage is not indicative one way or the other. And finally, Your Honor, I believe that Officer Shading testified that Ms. Stoinson indicated to him, or Ms. Stoinski indicated to him that she had a separate phone that she was able to use to call 911 as she exited the residence away from the defendant.
Today was a date scheduled for preliminary examination. Mr. LaPearl, the purpose of the exam is so that the prosecutor can establish on this record whether or not they have sufficient probable cause that the felonies in this matter, which is count 1 and count 2, were committed, and then sufficient probable cause to charge you as the person who has allegedly committed those felonies. This is not a trial. They don't need to prove each element beyond a reasonable doubt. It's a very low burden. It's just more than mere suspicion is all they have to establish. And in this particular case, it was slightly unique in that the alleged victim is not here to testify, but the law provides a statute that allows for testimony through hearsay to come in through the officer under certain circumstances. So that's why we heard today testimony from Officer Shading, who testified that he reported to the address of 6329 South Washington, which is in the city of Lansing, Ada County, state of Michigan, and that makes venue in this court appropriate, that this was on or about November 19th, and that on this date, he was reporting onto a dispatch for a possible domestic situation. And that the relationship between the parties is that the person he identified in the court as Mr. Devin LaPearl is the son of the alleged victim, that the parties lived or had been living with each other during the time of the alleged incident, and that the victim appeared shaken up or concerned that there were some bruisings or red marks on her hand and or wrist, and that she described an incident that occurred just prior to that in the kitchen, where she questioned her son about having some court date, and that it upset him that he grabbed her phone, or that he twisted her arm or hand or something to that effect, and that when she said she was going to call the police, he told her not to call the police, and grabbed her phone and threw it on the floor. The defense is arguing, and also that the victim reported that she had to exit the residence to make the call to the police. The defense has argued multiple things, and also questioned about the presence of the defendant at the time that the police arrived. That the defendant did not plead that he was still present, that the defense believes that there are issues with the trustworthiness of a hearsay testimony, because the victim reported about or apparently stated something about a court date that did not occur. Whether or not that court date occurred, the court's not clear, because we didn't have any testimony about whether or not that occurred. I'm not even in a position to take judicial notice, because the only thing I can assume at this point, because there's been nothing one way or the other, is that this is the case that in my file said he was on bond for. And that at the date that case was bound over to the circuit court on October 10th. I'm assuming that's the same case. I'm not sure. It could be, and the defense is also arguing that there's an issue of trustworthiness because of the statements about the phone being thrown, and not that there was no damage, and then also concerns about whether or not the victim had the ability to call the police or was prevented from that ability to call the police, because the victim did get to call the police from Mr. Goodrich's standpoint, from within the vicinity of the alleged incident. We've gone through the elements. As to the trustworthiness of the testimony, I don't have anything before me that would cause me to believe that there is a issue with the trustworthiness of the statements. Again, well, I don't know whether or not a court date happened or not, but whether or not a court date happened does not invalidate or make the court feel like we can distrust the statements that was reported, because the question was, my understanding is the question was posed as to whether or not the defendant had a court date, and that is what triggered the reaction of some sort. Whether or not there was a court date or not is really not germane to the issue. The other concern is the phone allegedly being thrown on the ground. I probably dropped my phone multiple times, outside and inside, but I have not a great case, so there is damage to my case right now. But then now they're putting screen protectors. I don't know anything about the condition of Ms. Lewinsky's phone, but that there was no damage. And so there could be, a question of fact as to whether or not that was thrown down to the ground the way it was described. But I don't think that there's an issue with that element that rises to the level that I should find this story to lack its trustworthiness. The other concern that the defense has brought up is that the victim or alleged victim was able to call within the vicinity. My understanding is that she had to leave outside the home to make that phone call. I will say it's not the strongest case, and I think the prosecution knows that. It's not the strongest. But do I have more than mere suspicion? I do, because we got a police that's responding to an incident and talking to this lady within short order of this alleged incident. She's got bruises or red marks on her arm, which is consistent with the story that she's telling, that something took place. And so if she's saying that the something that took place was that her son got upset and twisted her arm or caused some injury there, then there's more than mere suspicion. There, however, could be a question of fact of is that what actually took place or something else took place, but I don't have that for me. That's for the circuit court to flesh out. So as it relates to this particular file as charged, each count will be bound over to the circuit court for further prosecution, and your bind over date is going to be January 7th. Because we have some holidays back to back for the next 2 Wednesdays. And so your next court date is not a date that you actually need to appear. It's a date that the circuit court is going to receive the file from the district court. And then they'll set your next court date, which will be a pre-trial. Mr. Goodrich will be made aware of that next court date. Okay, Mr. LaPearl? Do you have any questions about that? He was on bond in another matter before Judge Stokes. Is that correct?
That is correct, Judge. That's correct.
And he's posted that bond?
So he had a PR bond on that file, I believe. He's currently being held without bond on that because they have a contempt hearing scheduled on Jan. I may just address bond at this time.
Yeah, I think we do.
And on January 14th, they've scheduled a contempt hearing for picking up a new case on that file. So he has a no bond hold until that time. I would ask the court to consider reducing the bond in this file from 5,000 cash or surety to 5,000, 10%. It's still something that would have to be posted. Like I said, you could talk to Jad about that. but like I said, he is 18 years old. He does have a place to stay. So I would just ask the court to consider that at this time.
Where would he stay?
It's my understanding that his mother no longer resides at that address. That's correct. So I guess I would ask him to be allowed to stay with his dad.
Where does his dad stay?
Which,
Is it 6329 South Washington? Oh, you stay there. That's your apartment, sir? It's your house? Okay, because I think previously he said he would stay with a cousin in Mount Pleasant, but Ms. Lewinsky does not stay at that address anymore, sir. Okay. Okay, and so, interesting. Okay. Because I'll note that the defendant, if postponed, can return home with his dad. Still, GPS tether will be ordered with victim notification if possible. But they'll obviously have to address the exclusion zone now because it did have 6329 before. Lastly, I will amend the bond to 5,000, 10%. But all other bond conditions will continue. Any additional matters for the record?
Not from the people, thank you.
not from the bench, thank you.
Thank you.
Yeah, thank you.
See. We're waiting on William McClendon to appear for the defendant, and we're waiting on the defendant, Misty Dawn Crawford.
They were on a phone conference, Judge, so they should be getting on.
All right. Looks like we have a number of witnesses ready.
hearing today.
That'd be fine, but we need your client. Is she with you or is she?
She'll be logging on shortly.
Very well, thank you. Ms. Gillette, you have all the witnesses you anticipate needing today?
I believe so.
Misty Crawford, if that is you, you need to start your audio and video, please. You need to click on the little red microphone and the little red camera with the lines through them. If you're on a telephone and you can't see those, run your finger down the side or the bottom of your phone, and they should pop up a little red microphone with the line through it and a little camera with the line through it. Thank you, Miss. You're Misty Crawford, is that correct? Misty Crawford, is that you? Can you hear me?
Can you hear me?
I can. Can you hear me?
Yeah, sorry, I had Bluetooth turned on and I had to turn it off.
All right. We are again on the record in Greenwood 2025 CR 104, State of Kansas versus Misty Dawn Crawford. Jill Gillette, County Attorney for the state, William McClendon, Attorney for the defendant as before. Misty Dawn Crawford, the defendant, has now joined us for what is scheduled for an evidentiary prelim. Mr. McClendon, I understand your client is still wanting to exercise her right to this hearing?
Your Honor.
All right. Ms. Crawford, this preliminary hearing is scheduled because you have several felonies. Count 1, conspiracy to possess stolen property. To win a 325-gallon propane tank, approximate value $3,500, as well as count 2, conspiracy to possess stolen property, a 500-gallon propane tank, approximate value $5,000. And I believe that's it, but let me double check and see if this is the next one. Count 3 is also a felony. Count 3 is possession of a controlled substance, methamphetamine and/or MDMA, a level 5 drug felony. But the remaining count, possession of drug paraphernalia, is filed as a misdemeanor. So it is those 3 felonies that entitle you to this hearing. And Ms. Gillette, are you ready to proceed?
We are.
All right, very well. Please call your first witness.
Your Honor, we'll begin with Jason Myers.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Well, you're going to have to start your audio, please, Ms. Undersheriff.
I apologize, Your Honor. I do.
Thank you. All right, Ms. Gillette, you may proceed.
Would you please state your name for the record?
Jason Myers,
How are you employed?
currently the undersheriff of the Greenwood County Sheriff's Office.
How long have you been so employed?
I've been employed with the Greenwood County Sheriff's Office since October of 2010.
And prior to that, what was your prior law enforcement experience?
I worked for the Kansas Department of Corrections for 9 years. I spent 2 years overseas conducting law enforcement and security support for the United States military.
And Did you receive information about a possible theft of a propane tank?
I did.
And when did you receive that information?
On the evening of Wednesday, June 18th.
And who had contacted you?
I had spoke by phone to Jared Walters.
And is he here with us today?
I believe I saw him on there a minute ago. I do believe, yes, he is.
And did he let you know about the propane tank?
Yes.
And what was the size of the propane tank?
The one in question was 325-gallon propane tank.
And who did he relay to you that it belonged to?
To the MFA Oil company or organization.
Okay. And is he a representative of MFA Oil?
He is.
And what address had the tank been at?
Mr. Walters told me the tank was supposed to be at 208 West Water Street in Severy, here in Greenwood County.
And
Near or, excuse me, near or in Greenwood County?
Here in Greenwood County. It's in
Okay,
Severy,
okay.
Greenwood County, Kansas.
Okay, I just didn't hear what you said.
And was there another propane tank that was supposed to be near the 325-gallon one?
Yes, didn't learn about the 500-gallon. Yes, there was supposed to be another one that was supposed to be near the 500-gallon propane tank.
Was that on a separate property?
Yes, I didn't know that until later, but yes, there was supposed to be another one that was either there or left on a property near it. It's all pretty close in Severy.
Okay. And how did he, or was there some kind of for sale post about it?
Mr. Walters had received, from what I understood, a call or something from one of his former employees who saw this 325-gallon propane tank posted on Facebook Marketplace for sale, and you could see the MFA Oil sticker that's on the side of the tank showing it's owned by the company.
And what did you do next after receiving all of this information?
We tried to figure out a way to see if we could purchase the propane tank.
Okay. And did you enlist Deputy Alford to help you?
Yes, several people were assisting, but yes, Deputy Alford did.
Okay. And so I know there's more than one individual involved. Who else was involved with this propane tank?
You mean like, law enforcement wise or on the suspect wise?
Suspects.
Well, at the time, we only knew of Misty Crawford on that date. Later, there were others determined, which was Melissa Barkis and William, known as BJ Cheever.
And where do they live?
1687 10th Street in Severy, Kansas.
Is that within the bounds of Greenwood County?
It is.
Now, did you start conversing with Ms. Crawford on Facebook?
We did have conversations that were made through Facebook Marketplace to try to set up a purchase of the propane tank.
And who did you enlist to help purchase the propane tank?
We had a fellow Greenwood County, Kansas resident. It was a Jared Seeley who was actually the one facilitating the on a Facebook post. So I didn't come back to see that it was a Greenwood County Sheriff's deputy.
Okay. And then who did you enlist to go and make a controlled buy of the property?
Sergeant Broyles from the Lyon County Sheriff's Office.
Is he with us here today?
He is.
Now, were you the one actually helping converse with Miss Crawford's Facebook profile?
I mean, I was there saying, hey, ask this much and see if we can get this and figure out a date and time.
Okay. And as you guys were doing that, What was the price that they offered to sell you the propane tank for?
$450.
All right. Was Sergeant Broyles provided with the cash from the Greenwood County Sheriff's Office?
He was.
Did you record the serial numbers?
I did.
And how did you record the serial numbers?
We took a photocopy and then actually documented each of the numbers in writing to show what they were.
And as you documented those numbers, then did you do anything else with Sergeant Broyles before he went to go purchase the tank?
Yeah, we did a little briefing about what we were looking to do and what we needed to try to purchase, and also gave him a digital voice recorder to carry on his person.
And then did you go to watch the sale of the propane tank?
I did.
And were you guys able to then make the purchase?
Yes, we were able to at least transfer the cash to them and prepared for a time to come back to pick up the propane tank because we didn't have a vehicle that could haul it at that time.
All right. And after making the transaction, did someone stay and watch the house?
Yes, I did.
And who applied for and was granted a search warrant for that house?
Sergeant Mike Cordell.
And then was the search warrant executed at the house?
It was.
What else was found at the house besides the 325-gallon propane tank and the cash?
A 500-gallon propane tank that also belonged to MFA Oil.
And that was the one that was located on a different property near where the 325 was supposed to be?
Correct.
Okay, I'm gonna have to stop you. Is the defendant gonna be joining us today or not? Ms. Crawford, I need to know that you're gonna stay here in this hearing. Why is your camera not on you? It is now, but why wasn't it?
I'm sorry.
All right, I just need to know that you're with us because this hearing is your right and you need to exercise the right to hear. And I need to see that you're doing that. All right, thank you, Ms. Gillette. I'm sorry, please proceed.
Under Sheriff, were there any other structures that were looked through?
Yes.
And did you verify the serial numbers on the bills that were given to Sergeant Broyles to purchase the propane tank with?
Yes.
Were you able to locate the sticker and barcode under the lid of the 500 tank?
Yes, ma'am.
And did it show that it also belonged to MFA Oil?
It did.
What is written on the sticker that's under the lid?
I'd have to look at my report if I can to see if I put it in there exactly what was written without looking at the photograph.
Okay.
Well, if looking at the photograph or looking at your report would refresh your memory, please do so, Deputy. or
Thank you, Your
Sheriff.
Honor. On the sticker that was on the white propane tank, it was under the lid and it had a serial number of 0014107117. There's also another one affixed to the tank that said property of and serviced by MFA Oil.
And did you transmit that information to Mr. Jared Walters?
I did.
And did he confirm with you that no one had permission to remove or sell those propane tanks?
He did. He told me it had no permission wasn't given for anybody to move or sell that tank.
Okay. And now was there other evidence found by other deputies while they were looking for the bills that the propane tank were purchased with?
Yes, there was.
Okay. were some of those illegal drugs?
They were.
Was a piggyback warrant applied for the drugs?
It was.
And after finding drugs, did you guys then do a search for further drugs and paraphernalia?
Yes, they did.
Now, did you interview Ms. Crowford about the Facebook post regarding the selling of the propane tank?
I did.
And did she advise that she had previously posted a propane tank for sale?
She did.
Did she admit that Barkus asked her to post the 325-gallon tank?
She did, yes.
And did she say that BJ Cheever had contacted her after she had posted the 325-gallon tank?
Let me double check, please. See that I have on here, she discussed Misty reaching out. I'm sorry, that is Misty. I'm sorry. Melissa, Mrs. Barkus.
Just on a side note, does Ms. Barkus go by Regina and her real name is Melissa?
I'm confusing them. It is Regina.
Okay.
It is Regina Barkus. I don't know how I keep getting Melissa, that name in my head here.
Okay. So did Ms. Crowford then admit that Mr. Cheever had asked her to also post the 500-gallon tank, but she hadn't posted it yet, only taken pictures?
The other tank, yes.
Okay. And then were you able to assist Mr. Walters in recovering the 2 propane tanks?
I was.
Okay. Your Honor, I will pass this witness to the.
Mr. McClendon, cross-examination of this witness?
Yes, Judge. Officer Myers, did you ever determine that it was actually Misty Crawford that you were talking to on the Facebook Messenger?
Yes, I did.
And how did you determine that?
Oh, while we were executing the warrant, Miss Crawford actually walked up to the house, and I actually met her out in front of the house. I explained to her what was going on. She's the one that told me that she had been asked to post that on Facebook by Miss Barkus.
Were there any pictures posted on Facebook that showed the label that it was owned by MFA Oil, that the propane tank was owned by MFA Oil?
I believe it was on that exact one that was posted, the 325. The 500-gallon was not posted at that time.
So is it possible that Miss Crawford was posting a propane tank that she believed was not stolen?
It's possible. I couldn't tell you. I just know that she was asked to post this on Facebook.
No further questions, Your Honor.
Any redirect, Ms. Gillette?
No.
All right, you may call your next witness, Ms. Gillette.
Your Honor, we will call Deputy Yvette Alford.
Very well. Ms. Alford, Deputy Alford, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Could you please state your full name for the record?
Yvette Alford,
How are you employed?
with the Greenwood County Sheriff's Office
How long have you been so employed?
since August of 2021.
And were you participating in this investigation?
I was.
Did you execute the affidavit for the charges?
I did.
And did you assist Sergeant Cordell with executing the search warrants?
Yes.
Did you guys, were you looking for the bills that the propane tank was purchased with?
Yes, along with proof of residency.
And did you end up discovering drugs within the house as well?
Yes.
And were you able to identify different individuals, rooms, purses, or items that were in the house?
Can you clarify that?
Were you able to identify who was in what bedroom?
Yes.
Okay. So was there a bedroom that belonged to Ms. Barkis and Mr. Cheever?
Yes.
And was there a bedroom that belonged to their son and Miss Crowford?
I don't recall a bedroom specifically for them, but I know there was one for Cheever and Barkis.
Okay. And did Miss Crowford have her purse with her at the residence?
When she came, while we were executing the search warrant, her and Zach Cheever arrived at the residence and she had the purse on her at that time.
And then were you able to conduct a search of her purse?
Yes.
And did you find anything of evidentiary value in that purse?
We did.
What was inside her purse?
There was methamphetamine and drug paraphernalia.
Okay. And with the drug paraphernalia, what different items of paraphernalia did you find?
There was 2 glass smoking pipes with residue and white crystalline substance, and then there was 3 small baggies, which are consistent with packaging of methamphetamine.
And did you send those off to the KBI lab?
We did.
And Your Honor, I believe the KBI lab has been sent to Missy, your assistant, to be able to show it.
All right, Misty, do you have it? Or can you produce it?
Think so.
Okay. You can proceed while she's looking for that, Ms. Gillette.
Did those items test positive for methamphetamine?
Yes. Presumptively.
Okay. And then.
Okay, let's clarify that. Presumptively, do you mean in field tests? And
Correct.
then you send it to the KBI?
Correct.
And then the KBI lab reports are on the screen now as what? States 1, Ms. Gillette?
Yes, we'll be moving to admit the misstates 1, and you will see that the broken glass pipe that was in her purse was positive for methamphetamine.
Any objection to admission of the lab report, Mr. McClendon? I'm sorry?
No objection.
Okay. All right, so according to the lab report, methamphetamine detected in lab item 1, which is the plastic straw, and THC, marijuana, and 2, which are baggies of vegetation, and 3, the broken glass pipe. Now I see that with residue methamphetamine. Thank you, Ms. Gillette.
And Deputy Alford, do you recall where the bills for the propane tank that were marked were recovered from?
The property on 10th Street, I believe is 1687 10th.
Okay. And do you know where in the house it was?
Can I refer back to my report?
If it will refresh your recollection.
I'm not seeing in my report where it was located.
Okay, that's fine. And deputy, did, you find anything else of evidentiary value?
Inside the house,
Yes.
I believe weapons were located inside the house, as well as the marijuana.
Your Honor, I will pass this witness to the defense.
Mr. McClendon, cross-examination.
So Deputy Alford, just for clarification, you're stating you only found marijuana and residue within the house?
The marijuana was located inside the house, yes. The residue for the methamphetamine was located inside of Miss Crawford's purse.
No further questions, Your Honor.
Any redirect, Ms. Gillette?
Not of this witness, Your Honor.
Very well. You may call your next witness, Ms. Gillette.
Your Honor, we'll call Sergeant Broyles.
Sergeant Broyles, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may lower your hand, and Ms. Gillette, you may proceed.
And Sergeant, could you please state your name for the record?
Danny Broyles.
And how are you employed?
I'm a sergeant with the Lyon County Sheriff's Office.
Did Greenwood County reach out to Lyon County and end up recruiting yourself to be a undercover purchaser?
Yes, on June 19th, Sheriff Samuels contacted me and asked me if I'd come assist them with the purchase of a propane tank.
And did you conduct the controlled buy?
Yes, I did.
Did you have a recording device on you that recorded the entire transaction?
Yes, prior to going to the residence, Under Sheriff Myers gave me a digital voice recorder that I placed in my pocket, turned it on, and then I went to the residence.
And did you end up conducting a purchase of that propane tank?
Yes, prior to going to the residence in Severy, Under Sheriff Myers had showed me a photograph of a white propane tank with a blue lid. He said that was the tank they were wanting to purchase. I then went to the residence at 1687 10th Street in Severy, knocked on the door, made contact with a white female who identified herself as Regina. I told her I was there about the propane tank. It was actually right along the drive, chained to a backhoe. She said that was it. I asked her if I could go look at it. She said she could. She said there was a second tank north of the house, setting beside a barn. She said she'd meet me outside. So I walked over to the tank. I had previously asked her if I could take a photograph of the tank, and she said I could. So while I was waiting on Regina to come outside, I photographed the white tank with the blue lid, the one that Under Sheriff Myers had showed me a picture of. And then I walked north of the house up the driveway and to the larger tank, and I took a photograph of it. And then at that time, Regina came outside and met me outside.
And who did you give the marked bills to?
I gave them to Regina.
Did you see what she did with them after you handed them to her?
I did not.
Did she return in the house with the bills?
Yeah, we were actually walking back to the house and a white male came out. I learned that that was William Cheever. We talked as we walked up the driveway. I told them that I would be back later for the tank, and they said no problem. They had the backhoe there. They would help load it. They walked in the what I would call the front door of the house, and I got in the vehicle and I left.
Okay. And I believe I'll just pass this witness to the defense.
Mr. McClendon?
I have no questions, Your Honor.
Very well. Ms. Gillette, further witness?
Your Honor, I will call Sergeant Cordell briefly.
Okay. Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please proceed.
Sergeant, could you please state your name for the record?
Mike Cordell.
How are you employed?
I'm a patrol sergeant and canine handler with the Greenwood County Sheriff's Office.
How long have you been so employed?
Approximately 9 years.
And then what is your prior law enforcement experience?
Total law enforcement experience. Been full-time certified law enforcement since March of 2004.
And did you end up helping with the search warrants and the searches of the 1687 10th Street in Sudbury, Kansas?
Yes, I did.
And were you the one that left and applied for the search warrant for the bills, proof of address, and the propane tank?
Yeah, I applied for those prior to our initial arrival on scene. Yes.
Okay. And did you end up having to apply for the piggyback warrant?
I did apply for a secondary search warrant for drugs. Yes.
Okay. And when you and Under Sheriff Myers ended up helping, or did you help arrest Crowford?
Yes.
When she was being taken into custody for assisting with the sale of the propane tank, did you guys do a search incident to arrest of her?
Yes.
And did she identify anything that would be in her bag?
I don't recall if she made any statements regarding anything that was in her bag off the top of my head.
Okay. And did you write a narrative report for this case?
Yes.
All right. And do you recall whether or not you put anything in your report?
Pertaining to Miss Crawford, I don't believe I think that was an oversight. I don't believe I did put anything in the report. I do recall the search of Miss Crawford when she was arrested.
All right. And the items were found within her purse?
Yes.
And do you remember if she made any statements about the drugs in her purse?
I believe she claimed ownership of the items that were in her purse.
And that was one of them was that broken glass pipe with residue?
Yes, I believe, if I remember correctly, the initial item I found in the purse was a methamphetamine pipe. And then there was a second pipe that was broken that was wrapped up in a cloth, and that was the one with the white crystalline residue inside.
And I think those are the only questions that I have of Sergeant Cordell. I will pass him to the defense.
Mr. McClendon?
No further questions, Your Honor.
All right. Please call your next witness.
Your Honor, we will briefly call Jared Walters.
Please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, thank you, sir. Please proceed, Ms. Gillette.
Could you please state your name for the record?
Jared Walters.
Mr. Walters, are you a representative of MFA Oil?
Yes, ma'am.
What's your position with MFA Oil?
I am the plant manager of Chinook and Garnett.
And do you help control the inventory that would be in the Severy area?
Yes, ma'am.
And would you be the one that records these 2 tanks that are of issue here?
Yes, ma'am.
And are you the person that makes sure that the inventory is where it should be?
Correct.
All right. Were you able to verify that these 2 tanks belong to MFA Oil?
Yes, ma'am.
Did you give anyone permission to remove them from their leased locations?
No.
And did you give anyone permission to sell these items?
No.
What is the value of the 500-gallon tank?
It's going to be real close to $5,000, maybe a touch more, just depending on the price of iron and things like that.
And what is the price of the 325-gallon propane tank?
It's going to be, again, real close to $3,500.
So both of them would be in excess of 1,500?
Correct.
And are they marked with stickers on them?
Yes.
Are they marked by serial number?
Correct.
And what address was the 325-gallon propane tank last leased to?
208 West Water Street.
Okay. Was that in Severy, Kansas?
Correct.
And where was the 500-gallon tank supposed to be?
The 500-gallon tank was supposed to be on my lot on East 15th Street, on the south side of East 15th Street.
And that's there within Severy, Kansas?
Correct.
And that's within the bounds of Greenwood County?
Yes.
And does MFA Oil own that land?
Correct. Yes, ma'am.
And did you give anyone permission to be on that land?
No.
Did you give anyone permission to remove that 500-gallon tank?
No.
Did you give permission for anyone to sell that 500-gallon tank?
No.
Your Honor, I will pass this witness to the defense.
Mr. McClendon.
No questions, Your Honor.
Very well. Ms. Gillette, next witness.
Your Honor, the state will rest, Your Honor.
Very well. The state rests. Mr. McClendon, does the defense wish to present any evidence at this time?
No, Honor, just statements.
All right. Well, if we're going to have arguments, Ms. Gillette, do you have any?
Your Honor, the methamphetamine pipe was on Miss Crowford. She admitted that there was going to be a meth pipe and drugs at the time that she was arrested. That was on her person, in her purse, in a search subject to arrest. When someone's arrested, they are subject to search. It was found on her person and she admitted it. It tested positive at the KBI lab for methamphetamine. Miss Crowford used her Facebook to help sell the 325-gallon tank, admitted that she had done so. She also had taken photographs of the 500-gallon tank. There was going to be a search warrant executed on her phone, so those were going to be eventually found anyway. And she admitted to having photographed the 500-gallon tank to assist Mr. Cheever in trying to get it sold. Neither of those tanks were where they were supposed to be. They were removed over to the Cheever Barkis house where both of them lived at 1687 10th Street within the bounds of Severy. The 2 places they were removed from were 208. Hold on a second. The original address was 208.
West Water, is that what you're looking for?
Yeah, the West Water address. I just wanted to verify it before I.
Okay.
208 West Water in Sudbury. And the other one is there. It's on the main road as you come into town from the north. He described it as 15th Street. It is on the south side of the road, as Jared Walters indicated, and that is a lot belonging to MFA Oil Company. And obviously, that's not where someone would live. It's owned by the oil company to have their larger propane tank on to store propane, and it was removed from that location without permission. None of the parties had permission to sell or dispose of these propane tanks. And Ms. Crowford admitted to working in concert with Ms. Barkis and Mr. Cheever to photograph the 500-gallon tank for sale that was needing to happen, or she was going to do for them, and actually placed the ad on Facebook and helped with the sale of the 325-gallon tank, which be conspiracy to possession of stolen property and to sell it, count 1 and 2. And count 3 is the meth. So we'd ask that she be bound over on all 3 felony charges.
Mr. McClendon, argument?
Yes, Judge. The state's failed to establish that the defendant knew the propane tanks were knowingly stolen. She thought she was doing a favor for her friends, and therefore, Your Honor, count 1 and count 2 should be dismissed accordingly.
All right. Well, I didn't hear any testimony or evidence to that point, but one could assume that a possibility. This is not the trial where the evidence has to be shown beyond a reasonable doubt, but rather as it is a preliminary hearing. I do find the state of Kansas has met its burden of producing evidence to make it appear that each of these 3 felony crimes has been committed and that they show probable cause that this defendant committed them. She's not charged with the actual theft, but conspiracy to possess in both counts 1 and 2, and I believe probable cause is shown. And then the third count is the methamphetamine, unlawful possession of methamphetamine in count 3, and I find probable cause on that as well. The defendant is bound over for arraignment. Missy, when will that be?
This case will go to Judge Hart, and you can do arraignment. January 8th at 9 a.m.
I can do that, Judge.
All right, this is continued to January 8th, 9 a.m. via Zoom before Judge Hart. Miss Crawford, you must reappear at that time by Zoom with counsel, prepared to answer to these charges at arraignment. That will be a condition of your bond. If there's nothing further, we are in recess. The witnesses, the defendant, and Mr. McClendon are excused. And Missy, do we have another prelim waiting to start?
No, we're done until 1:30.
All right, then Ms. Gillette, you're excused too. Thank you.
We'll see.
Mr. Malafide do a little work and see what the next step is. He'll come in and advise. Keep in mind, you already know Mr. Malafide. Take some deal and make sure he fully applies his advice or rights. Not unless you just want to go straight to trial and set a trial.
We may, Judge. I gotta figure some stuff out and talk to who is the attorney in this courtroom?
Horn. She's in a breakout room 3. I'm gonna put you in 5, Mr. Lyles. We'll pass the matter. Join the room. All right. We're talking about Garcia, right?
Good morning, Judge. I'm William Gregory. I'm not seeing him checked in though.
I don't believe he's checking in either. Is that the only one you have?
It's the only one today, Judge. Much easier day.
All right.
How do you check in? Like,
you checked in, sir. Good morning to you.
Oh, I'm sorry. I didn't know you can hear me. How do you do that?
I'm going to mute you, sir. You'll be able to unmute yourself when you see the prompt. Mr. Boffman, are you ready on anyone?
Yes, Your Honor. I want to thank you for the opportunity to meet Mr. Anthony Lindsay this morning. We've had a chance to go in the breakout.
Okay, so give me 1 second. City of Detroit versus Anthony Fitzgerald Lindsay, case number SB 176-18091, SB 181-1844, counts 1, 2, and 3. Appearance for the record, please.
Good morning, Your Honor. Harry Boffman on behalf of the defendant P55052. Mr. Lindsay, give the court your full and complete name, please.
Anthony Fitzgerald Lindsay.
Thank you. Judge, I'm thankful for the opportunity to speak to the defendant in the breakout room. Today is a date and time for a pretrial. We're asking if the matter can be reset for a pretrial. I'm going to order up the discovery that the defendant wants to see, and we believe it has exculpatory value. And we'll make a decision based on that information and material at the next action date. Would you set this for a pretrial, please?
Pretrial date, he's got a no insurance proof that he owes $288 on.
Yeah, we spoke about that. He's going to bring himself back online with respect to his license by the time we come back.
On these other 2 cases, I don't know when those dates will be set, but we'll set the review on that same day as well. January 9th, 2026 at 8:30 a.m. Mr. Lindsay, if you don't have any further questions, you have a safe, happy holiday season and best of luck to you. Okay?
I'm sorry, sir. I didn't hear the date. January 9?
January 9.
Okay. Thank you.
All right. Have a great day.
You too.
All right. Thank you.
You as well. You have anyone else, Mr.
That's it for me, Judge. I hope you have a great weekend. Or if you need me, just let me know.
All right. Very well.
All right. Bye now.
Morning to you. Who's your client? Good morning. What's your name, sir? Jerry Lewis. Jerry Lewis. Yeah, your attorney's here. Good morning to you. Can you give them an advice or rights form, please? You don't already have one in file. We have one. I'm sorry. We have one. Thank you.
They should be on the,
Yeah, I have one in here though.
but they should be on top of it.
All right, do we have any other attorneys in here ready to go?
Are they sitting on top?
So this is Attorney Kevin Bassano. I'm checking in on Miss George, and it was set for a bench trial this morning.
And who is this? Good morning, Chief Officer. I mean, Attorney Bassano. Who's your client?
Tanea George, George. First name Tynayaa.
Very well. She's here. City of Detroit versus Tanea Nicole George. Case number SP 1806400, counts 1 and counts 2. Appearance for the record, please.
Good morning, y'all. Attorney Kevin Bassano, P71061 on behalf of Ms. Tanea George. Ms. George, please state your name for the record.
Tanea George.
All right, good morning to you, Ms. George. Mr. Officer Ireton is here. What I'm going to do is, Officer Ireton in this room, he did check in. I do not see him in the room now. What I'm going to do, Mr. Bassano, is I'm going to put Ms. George in breakout room 8. That'll be your breakout room for Ms. George. Keep in mind, if Ms. George takes the deal, make sure Ms. George is fully advises her advice or rights. I'm going to put you in breakout room 4 to speak with the city attorney, and then you can see if you can work it out. You have the ability to move from breakout room 4 to 8 for your client. All right.
No problem. Thank you, Your Honor.
All right. Ms. George, join breakout room 8, please. Wait on your attorney, and we'll pass it back. Officer Ireton, he's here. Back. Officer Ireton, your case was called. They're working it out now.
Thank you. Sorry about that. I had to log into Judge King and check in there.
Let's go back on the record with Ms. Gardner. Ms. Gardner, I'm giving you again an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, the current offer of the people is to allow her to enter a plea to failure to display for the driving on a revoked license, as well as improper plates for the no valid registration charge.
Well, no valid registration is a civil infraction, so we'll just leave it at no valid registration, right? Last charge.
Okay.
All right. Ms. Gardner, are you contesting the fact that you had valid registration on that day?
Am I attesting that I have valid registration?
Are you contesting that fact?
Oh,
that you did have valid registration? Right, did you have valid registration on that day, ma'am?
Yes, it's valid registration on the vehicle.
There you go, Mr. Berry. She said she had valid registration as well. On that day, was the registration valid?
Yes, it's not my vehicle, but the registration was valid.
Okay. Did you show proof of the registration being valid?
No.
I believe you have to be able to show proof.
Okay.
This is not a series of offenses in Michigan that allow you to deny bond. We're certainly not asking for that. This is a felony of home invasion 3rd degree, misdemeanor stalking, and misdemeanor entry without permission. Your Honor, we are asking for a $25,000 cash or surety bond in light of the fact that we cannot ask for you to deny bond. I get that he is a man of means, and so this is a bit of a nominal monetary ask, but quite frankly, it would be an ask that I would make for any defendant charged with these offenses before you. So what strikes me as perhaps more important in this scenario are conditions that I would like to ask for, because of course, as you know, Your Honor, you're tasked with trying to make sure that he reappears, but also the safety of the public and this victim in particular. So Judge, in addition to an ask for a $25,000 cash or surety, we are asking, should he post that, should you impose that, we are asking that you order that he undergo a mental health evaluation. We are asking that you order him to submit to a GPS tether and that there be a no-go to this victim's residence or place of employment. Ask that you order that there be no contact with her whatsoever in any means, any fashion, direct or indirect, that there be no stalking behavior of any kind, that he be ordered to surrender any and all weapons, further that he be ordered to surrender his passport. Judge, the reason, Your Honor, the reason we make those requests is in light of the factual scenario that gives rise to these charges. My best understanding from a thorough review of the police report and as much body-worn camera as I've had an opportunity to review is that I understand that our victim broke up. They had an intimate relationship for a number of years, defendant and victim. That our victim broke up with this defendant on Monday morning early, that there continued to be defendant making numerous phone calls and sending numerous texts from that time moving forward that she did not answer, did not respond to, and did not want. That eventually she presented herself to the University of Michigan, cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the address that is alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated, the totality of the behavior is highly threatening and highly intimidating. She was terrorized, Your Honor. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim. And it is for those reasons that we are asking for those specific conditions. I'm more than happy to answer any other questions that the court may have or give you further information. And I appreciate the opportunity. Thank you, Judge.
Simon is the bottom. Your Honor, let me start at the end where the people ended. In terms of risk to public safety, my client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threat to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to the public safety. The next thing is that the people referenced the court rule that I want to come back to, that you can't deny bond in a situation like this. And they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report and they reviewed thoroughly the body cam. I've had none of that opportunity. And that's too early for that in the proceedings. So when people come in here and make factual representations, although I trust Ms. Mirsky very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court. The monetary bond component, the two considerations by court rule are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel here. The second thing is that my client is not otherwise a danger to the public or danger to the complainant. There are other, that is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client will gladly comply with that request. The second thing is my client having no contact. Certainly, we have no objection to that order, and my client would be at his own peril if he were to violate that. His bond would be summarily revoked. In terms of surrendering the transport of passport, Your Honor, there's no really indication that he is a flight risk. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court like everyone else does. There would be no leaving the state, let alone the country, without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding, again, without being privileged to have reviewed discovery. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been in Washtenaw County Jail since. I can also tell the court that the Community Mental Health Department saw my client yesterday for an evaluation as well, without any further recommendation. If you make that a condition of bond, I can tell the court that he get a mental health evaluation, he will absolutely comply and follow any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount. I forgot to speak about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, we all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles, not of my client's bank account, but to the principles of the charges and to the principles of the court rule. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with a $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significantly to try to get that in place in time for what we hope to be as early as today. Thank you.
Mr. Moore, could you state your name, please?
Jerome Moore.
Sir, you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you will be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record. but you may not go to that location for any reason whatsoever. Are we understood on the no contact and no go to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. You understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety as requested by the prosecution's office. This court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court appearance within 14 days. I've discussed that with him. I also try to coordinate calendars with Ms. Wisniewski. In support of that, I think we're both available on January 22nd, if the court would order that. And I'll add one more thing for the record in support of that. I understand there is continuing investigation. So in addition to the discovery I don't yet have, there may be even more. So
it will be January 26th, 2020.
22nd, 15, 22nd,
22nd,
29th.
Thursday.
January 22nd, then January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you very much.
All right, we're off record. We're going to give 10 minutes for everyone. Court's going to take a recess.
All rise, please. Magistrate, if Katie, can you? Sure.